as a condition. So the private health establishment can be told, you can get your certificate, but you will have to train people. Whether or not you have the resources, who knows? So, and then there's any criterion contemplated in subsection 3. So then we go back to subsection 3, which is all of these matters of, that are listed there in A to M. So when...
That's what we've dealt with in sub 5 and the conditions. The conditions that we've gone through in 1, 2, 3, 4, and 5, are those conditions to regulating the industry, or are those conditions related to what they say is the purpose of this act, to increase access to health care?
It's not entirely clear, because it might be that the nature, type, or quantum of services to be provided might relate to the purpose. But it's not clear to me how that can be, because if the idea is to make healthcare more accessible, why does the Director General need a power that enables him to limit the quantum of services that is being rendered by a particular healthcare practitioner?
Let's perhaps look at this at a sector closer to home, the Legal Practice Council, for example. What is the function of the Legal Practice Council? What type of regulatory body is it, and how does it regulate the practice of law in the profession?
Well, it regulates at various levels. It starts with the admission by court, but only with the assistance of the Legal Practice Council confirming that the necessary requirements have been met. And then, of course, there is payment of a fee to it as a regulatory body, and it has certain standards that are then imposed. There are disciplinary powers, for example, when that is not complied with. If I may add, all of that exists for the health profession already. The Health Professions Council does that. There is oversight of the professional duties. This certificate of need is not concerned with that sort of regulation of the, as it were, the quality of the services, or making sure that people are complying with their ethical duties, like, for example, the LPC might.
This is not merely regulation of the profession, controlling the standards. It's going further.
In fact, it is decidedly not controlling standards, because we've got the different statutes, for example, the Allied Health Professions Act, and under these various statutes, there's regulation of professional standards in the way that the LPC would do. Then there is also in the National Health Act, Chapter 3, and that enables the department to set certain norms and standards about what facilities must look like and what quality they may have. So there is already in place all of what is needed to ensure that the quality of the services is rendered at an acceptable level, and that it's rendered in accordance with professional duties. This is not that. This is, as it suggests, and as is conceded, an aim to say, we will decide whether or not there are enough of you here, and if there are enough, we hope you'll move elsewhere, because you won't get a certificate of need here. It's not about standards, although that is a case the respondents make, but that's provided for elsewhere. Yes.
Also know that we have challenges with access for justice. Would it be possible to introduce an act like this in respect of attorneys and advocates? How could it be done? In what manner would it be able to be done?
Well, I would suggest there would be far more applicants before this court than there are today, because I don't think the lawyers would take that. But that is exactly the point. Because what is it that we do as legal practitioners? Yes, there is access to justice rights, and there are ways of dealing with that. For example, that we must render pro bono services. Now, under the Legal Sector Charter, we assume certain obligations in order to train people and to promote access to justice. We can have, under the LPC, community service obligations. All of that can be done to assist in promoting access to justice. But the suggestion that we say, well, you are senior counsel in Johannesburg, there are too many of you, we need somebody in Kuruman to be senior counsel. So you can apply there. It would be inconceivable. It would be inconceivable in submission. You don't fix the problem of access to justice by moving around the people who render the services.
At rationality, does the first to seventh applicants concede that there is a nexus between the purpose of addressing the disparity in access to healthcare with the requirements or the contents of Section 36? And let me put the second question. If there is a nexus, is the test for rationality not met?
Well, in submission, there isn't a nexus. Because it is not good enough, that's what EFF says. It's not good enough to just say, I want to promote a very important public good by these provisions. What must be done and what must be shown is that my intention to promote this public good will be served by the measure that I have proposed. And then, of course, when we say it's not possible to improve the quantum of healthcare services in far-flung areas through this scheme, then the main objective cannot be met. And if the main objective cannot be met, then the scheme in its entire conception is irrational.
What does the respondent say to the applicant's assertion that these measures in Section 36 is not going to prove access to healthcare?
Well, maybe I will leave it to Mr. Maineche to answer that question, but I did indicate to the court earlier that they, in explaining...
Do you understand the respondents to be saying?
Well,
in answer to that question.
What they say is they hope, hopefully, and I quoted that earlier, I gave the reference to the court. They say that hopefully, taking into account what the requirements to obtain a certificate of need are, hopefully people will apply to go to the far-flung areas. That is the answer.
Is that not enough to meet the rationality test?
No. In submission, no. In order to upset an entire structure of how the healthcare professions work on the mere hope is not good enough, number one. And number two, if there is to be a hope, it must at least be grounded in reality. And the reality, as I indicated earlier in my address, is that once it becomes onerous to practice either where you are, or onerous in the sense that there is an expectation that you must move elsewhere, now the opportunities open up. And now the healthcare practitioner might legitimately say, if I have to go to Kuruman and that's not where I want to be, I might also not want to be in some far-flung place in Canada. But I'll start considering that. And then what happens is through regulation, through excessive regulation of healthcare practitioners, that we can ill afford to disincentivize them to either study the health professions or practice in the health professions.
Thank you, Ms. Engelbrecht. You introduced your argument by sort of taking us into the hearts and minds of a few healthcare professionals. And I suppose this case is fundamentally important, not just for healthcare, but in a sense for transformation in South Africa. And whatever the outcome might be, there must be some fundamental questions that we need to confront, and we may need to confront them in this case. And let me start with that I suppose one would see the importance of this case depending on one's vantage point. You've given us the vantage point of the first 7 applicants. But imagine someone living in the village of Gapasha deep in Skokuni may also be looking at this case with hope and expectation that their lives will change through the provision of healthcare services. And I think you don't take issue with that. However, you do say in your written submissions that this case is not about access to healthcare, Section 27.3. You say it's not about whether it's legitimate public objective, etc., and it's not about denying the grave injustice that millions of people face. You say it's not about that. And in your oral submissions, you say that the responsibility of the state under Section 27, subsection 3, is not one that must be foisted on private healthcare practitioners. So I want to ask you, as a matter of principle, do you say that in a society such as ours, where there might be a skewed distribution of healthcare services, and many academics have written about this, Professor Alex van den Heever speaks about the growth of the private hospital industry and sometimes the incentive to overservice. And public hospitals may not have, there'll certainly be no incentive to overservice. I'm not suggesting that that's par for the course. I'm just saying that there are those discussions. So under those circumstances, when there is a pool of resources and there's a massive need across the country, are you saying that individual rights, the ones that you rely on, the right to your profession, etc., freedom of movement, etc., will always trump, as it were, the transformative objectives? And my direct question is, can a certificate of need ever be found to be unobjectionable if it has that objection of moving resources?
If a certificate of need had the capacity to achieve transformation in the way envisaged, then of course it would have to be weighed. There is the justification exercise. In other words, we will look at the infringement of the rights, we will look at the reason for the infringement, and there will be a justification analysis done. But in that justification analysis, because it is the state that has to, for example, in this case, promote healthcare, and in aid of performing its duty to promote greater access to healthcare, wants to infringe on the rights of individuals, it would have to bear the burden of showing that the way in which it has chosen to do this doesn't go beyond that which is justifiable, and that there is not another less intrusive means to achieve this same purpose. So it's not a question of never trumping, but it is a question of an appropriate balance that has to be struck. And when that balance is struck, it has to be that there is a proportionality between the infringement and then ultimately the outcome that is achieved.
Thank you. Talking about the justification analysis, is it your understanding that when the High Court embarked on its justification analysis, it really posited these individual rights against the nature of the intrusion and reached the conclusion that the limitation was not justified? I'm not sure if I read it correctly, but I didn't get a sense that the High Court sort of posited individual rights with broader community rights, which is also part of our jurisprudence, because sometimes we deal with limitations and we have to look at whether the limitation is reasonable and justifiable in an open and democratic society. But sometimes rights compete with each other. And this court had to deal with that in numerous cases where, and it still happens within a framework of a limitation, but it's really a competition, maybe that's the wrong word, but where rights come into, where individual rights and communal rights might. And this court has said there's no magic formula. One must go back to the Constitution, you look at your limitations, and you find the balance, as it were. And so that's really the difficult issue I want to explore with you, whether under any circumstances it'll always be individual choice as to where I want to practice and how I want to practice that ultimately will carry the day. Because if that is where we ultimately go, then that is where the society will ultimately stay.
If I may
it may be an unfair question, but it's one that's at the heart of this application.
I understand that. The issue that we made and the point that also the court below made is that the difficulty with that section 36.3 analysis is that it is entirely, as it were, government-centric. And let's read government-centric then for the interests of the community. What it doesn't do in any way, in any of those provisions, is to at least also bring into account the rights, the aspirations of the individuals. Okay. So what we say is the section in and of itself doesn't provide for the balancing. It only looks at the one side. So if our criticism is we only look at one side, well, that's also a criticism of the legislation. Of the legislation itself.
Good. And then just lastly, getting to section 36.3, you raised your concerns about the vagueness. You would accept even the best drafters have their legislation scrutinized on a daily basis, because that's human nature. Depending on our vantage point, we seek to give different meaning to words. And courts are called upon to interpret them, and over the course of time, what may be vague gels into, and if we look at all the sort of legislative history in our democracy, this court is often called upon to interpret an individual word, and that's par for the course, if I could. And so I have two questions really, that over time, certainly 36 will, in a sense, develop its own coherence. And if there's a vagueness, is it of the kind that would render it at this stage unconstitutional, or is it of the kind that may be associated with, in a sense, the interpretive exercise that we invariably engage in? And my second question is that, would you accept that a decision of the DG under 36 would be subject to review under PAGA? Because
I want to answer those two questions together.
Okay.
It is quite interesting because instinctively the answer would be this is an administrative decision and therefore it would be subject to review under PAGA. But what the respondents say at various points in their answering affidavit is this decision that the Director General will have to make is a polycentric decision. And it bothers me. It bothers me because I am foreseeing into the future that when that decision is sought to be reviewed, that will be the answer. It was a polycentric decision and therefore not subject to the standard review under PAGA.
Yeah, but Ms. Ember, it's not really what they say about it, isn't it?
Yes.
PAGA has a definition that if it's external action that it adversely impacts on the rights of somebody, and from your initial description, it would fit neatly into PAGA. And it would be for a court to make that determination whether PAGA is applicable. And the simple point I wish to make is that if PAGA is indeed applicable, which I think it is, then PAGA provides for an additional layer of safeguards, as it were, with regard to ensuring that the administrative action that the Director General takes under Section 36 is subject to the pretty tight regime of both PAGA, but also in terms of how legality review has advanced in our courts over time. So in a sense, in that way, there is a framework, but as you point out, we're looking into the crystal ball.
But it's not just looking into a crystal ball. Justice Colopin, you point out that over time there might be interpretation and guidance given. But in the meantime, the power of the minister, well, first of the DG and then of the Minister on Appeal, is to make these decisions and to afford its own interpretation. So what we are saying is, well, in due course they might develop an interpretation that would trammel the powers of the Minister and the DG, and therefore we can over time make the statute constitutional. In submission, that is not the appropriate way. It's not for these individual applicants to have to go and apply, be knocked back. Who knows how long these decisions will take, because we know what happens in other applications, for example, for mining rights and the like. Make the application, get knocked back, go to the Minister, wait for however long he decides to take on the appeal, because despite the prescripts about how long appeals must take, it doesn't happen in that time period. And then go to a court on review, and Deputy Chief Justice Mlambo, I think, is maybe most acutely aware of all here, how long it might take to ultimately have that review heard. And so 3, 4, 5 years down the line, what has that practitioner, that health practitioner, been able to do? Not increase access to healthcare services. We can't say that it will be fixed in due course by case applications. If the Act is unconstitutional on its face now, it should be declared so.
No, I accept that. My question was posited on the understanding that if there's an argument that even if it's vague, it's not sufficiently vague to render it unconstitutional, but I think your argument is that on its face, it's unconstitutional. And so just lastly, and I don't want to put words in your mouth, but you suggested that a certificate of need may well be constitutionally acceptable under certain circumstances.
Well,
if that is so, would you describe what those circumstances may be?
Well, I think that's maybe where the difficulty lies. I was answering a hypothetical to say, is there a possibility that some sort of scheme like this might be constitutional? Yes, of course, it is possible. On my feet, thinking about what that would entail, well, it would at least, compared to what we have now, entail that the powers of the Director General and of the Minister are more clearly circumscribed, number one. Number two, that if we are talking about what is an equitable distribution of healthcare services, that be made clear. What equitable is, what the standard is, will have to be made much, much clearer. What will have to be made clear is that there can be no compelling of people to render services where they don't want to, or to share their services if they don't want to. That may carry consequences for them, but they can't be compelled. There are a variety of, it is quite difficult. It's something I thought as I was preparing for this, because I thought, is there a way that surgery can be done, for example, to these provisions? And I thought, on balance, no, because this scheme, as it is now conceived, is so intertwined, all the different provisions, that starting to do surgery will have unintended consequences. So maybe Parliament must be told to start afresh with some guidance on specifically giving direction to the Minister or giving direction to the Director General. But in our submission, the certificate of need really isn't needed. The certificate of need is not the solution to the problem. And so maybe the government could look to other means of rather truly transforming the healthcare industry, making available services by ways less intrusive on the individual rights.
Yeah, but that brings us back to the same problem. Because if individuals have free choice as to where they want to practice, where they want to live, then we're stuck there. And maybe that's where we'll be. I'm not sure. Thank you.
Well, if the state is operating on a hope here, as they tell us they are, well, why not give content to that hope, for example, by establishing public health facilities, by incentivizing people with a carrot? In other words, offering the type of salaries for people to go to the far-flung areas, as they do already, for example, in relation to community service and internships, where they give preference and higher income to those who are willing to go to the far-flung areas. They can do that. They can incentivize, but they shouldn't be compelling.
Okay, thank you, Ms. Engbrecht. Just finally, I mean, the entire Constitution and our entire presence here is based on hope, isn't it?
On?
On hope.
That is true.
Ms. Engelbrecht, Justice Majid still wants to ask you questions, but he'll do so after our tea adjournment. We're going to be adjourning for 20 minutes.
As it pleases you.
Court Deputy Chief Justice and Justices of the Constitutional Court. I appeared together with Ms. Chavedi, Ms. Deepa, MX Mukhorwa. Covered, but I share this concern about ours is a transformative constitution. So I share this concern that on the face of it, Judge Miller, that my brother Kolop and Jay raised with you, Judge Miller seemed not to have taken into account adequately, if at all, this section 27 obligation really that's on government. It's a right, it's also an obligation on government. When it did the justice, I ask because, as you say, I think at some stage the previous president wanted to put this part of the Act into operation, but he couldn't do so, sans regulation, so I was wondering what happened to them. So, last question on costs. The respondents say that this is a purely commercial interest that you're pushing here for your clients, and you shouldn't be entitled to biowatch protection even if you don't succeed. Also those individual applicants like Ms. What's the lady from Naisna, Ms. Pretorius?
If people raise genuine constitutional challenges, then they should be protected from a cost order. And we say at least the analysis of the High Court supports that this was a genuine constitutional challenge.
Thank you. Thank you, DCJ.
Ms. Engelbrecht, may I ask you about the Section 36 limitation? The question would be whether the respondents have placed any evidence to justify the limitation or not.
Yes.
Is there somewhere in the papers where that justification exists or not?
We say no, because we say there is only the expression of the hope. And if we go back to the question that Justice Majid mentioned, or the observation that he mentioned again, the idea of a transformative goal. It is so under the, and we find it specifically in the jurisprudence on affirmative action. What we know is that we want to achieve transformation, it is important that it be done in accordance with a properly conceived plan, that it is not a haphazard plan, I think is the language that Justice Moseneke has used. And so in this case, we say there is no justification because there's this intention, but there's no evidence that in fact it will be capable of being achieved. In fact, we say quite the opposite, because if once they accept, as they do, that they can't force people to move, then how can they achieve the objective?
Well, just to draw your attention to a judgment of this court in Samu, which says, it's a judgment delivered on the 9th of April, Samu versus the Minister of Corporate Governance, which talks about, you perhaps can have a look at it, about the failure of a party to adduce or submit empirical evidence to justify the analysis, the limitation rather.
Yes.
And if that were to be the position that you adopt, that even though we know that hope springs eternal, but hope has to be backed up by evidence, absent any evidence, that justification, you would urge us not to find that has been met.
Exactly.
All right, let's go back to what you have traversed with my colleagues on the government stated purpose in introducing the certificate of need. I probably would approach it differently. I just want to know from you whether my approach resonates with you or doesn't. One has to go back many years ago and ask ourselves that we are now 30 years into our democracy, and we cannot always be complaining that we are a young democracy. We've had this state of health over a number of years and nothing has been done, or maybe something was said to be done and not good enough had been done to try and resolve our dilapidated state of health. From where I come from in my village and where I grew up in Soweto, the closest hospital is Baragwanath Hospital, Chris Hani Hospital. When you go there, the ratios of a patient to a doctor are horrific. Could be 1 to 50, 1 to 30. If the government or the respondents say, we want to address those disparities, we want the people to be afforded the proper health care facilities. And for us to do that, we have to decentralize and move people to far-flung areas, like the village where I come from, where gone in the days we would have one doctor on a Wednesday for the whole village of so many people. And the government says, the purpose is, we don't want your villages to be suffering because there is an over-concentration of doctors in the city centers or in the more affluent areas. This certificate of needs, its purpose, is to ensure that there is access to a broader society or a broader community of South Africans. And we think that would go towards addressing those disparities. Would that not be a good government purpose?
The government purpose is a wonderful purpose. The idea that people in far-flung villages should have access to healthcare is obviously a good purpose. But if we want to achieve a good purpose, then we must adopt means. Sorry. If we want to achieve a good purpose, then we must adopt the appropriate means to achieve that. When you, Justice Matopo, speak about the fact that there is not a hospital in Soweto, whose failure is that? Is that the failure of the private practitioners? Or is that the failure of the government 30 years into democracy, not having built a hospital in Soweto? Is it not the failure of...
There is a hospital in Soweto.
But,
it's Chris Ban. It's one of the largest hospitals in South Africa. But, or used to be.
Yes. I'm just making the point because, in fact, that's a point that is made in the papers where I don't know if the justices noticed it, but there's some presentation that was made that shows that there are, I don't know, 9 hospitals in Parkhurst and none in Soweto or something of the sort. That's the sort of submission that is made. But that is not something that is to be placed before the private practitioners. The problem is also, if we're talking about hospitals, that's something entirely different from the individual private practitioners. And the problem with this scheme is it doesn't only deal with, for example, large-scale investments, putting up hospitals, getting licenses for beds and the like. It intrudes into every little practice. It intrudes into maybe the wife and mother who doesn't want to have a full practice, who wants to see patients in the morning and in the afternoons, spend time with her children. Maybe she doesn't want to go to another place. So that's
Sorry to interrupt.
That's the problem. It doesn't address...
Sorry to interrupt. Do we know how the DG, in his wisdom, he's going to decide whether to renew, withdraw, or we are putting the cart before the horse. We have to wait for the regulations. Or as it is now, the premise would be to look at the Act as it stands and ask ourselves the question, whether the Act as it stands, including the impugned provisions that it sought to be asserted, whether those impugned provisions infringed on the rights of the health practitioners, let me use health practitioners, or not. And if it does, would it be fair to say we should, or their devices, or no, not their devices, their fate, rather, should be left to the hands of the DG, who may decide that it's not good enough, you have to move. I just shudder to think what would happen if the same were to happen in the legal fraternity. I think if you were to be told, to use your example, to say go back to Kuruman, you would kick a lot of dust to say, I'm not going there. I have a right to practice here. But are we comparing apples with apples there?
It's always difficult to make comparisons because, in a sense, one would say that maybe in the hierarchy of rights, the access to healthcare might by some be considered to stand higher than, for example, access to courts. But when we start to draw these distinctions in order to justify intrusion in one profession and that over-regulation in one profession, I would submit we start on a slippery slope where we start deciding as between professions which one is more worthy. As to the question, Justice Matopo, about the regulations, I think it's important to say this. We cannot wait for the regulations. And even if we were to wait for the regulations, there are certain things that the regulations, no matter what they do, cannot fix. And one of those is the fact that the Act does not compel the DG to take into account the personal circumstances, at least amongst the factors that must be taken into account. So Justice Colopin asks me about the potential for a PAGA review, for example. Now, let's assume there are regulations, and let's assume the decision goes against the practitioner, and the practitioner wants to review. He wants to say you didn't bring relevant considerations into account, including my own life here, my practice. And the answer could legitimately be, well, Section 36 doesn't countenance that your private circumstances be taken into account.
Can I ask you, what is being contemplated or envisaged? Is that the practitioners would ask or would apply for a license, and the DG would be sitting alone or with his or her team? Do we know how this exercise is going to be conducted?
Well, it will be delegated. That's what they explain. They say, just like any other license procedure, there will be a delegation. How precisely and practically it will work, that one can only see, not even with regulations, one can only see that if it were ever to be implemented. We say we shouldn't be doing a social experiment with those that we so desperately need to provide healthcare services in this country, just to see whether it works out.
And I'll tell you what my concern is. My concern is the practitioner's fate being determined by some bureaucratic official somewhere in whatever room and say, right, you've got a license, you don't have, here are the conditions, meet the conditions. If you don't meet the conditions, you can't practice. I think it's horrendous.
We obviously share your concern, Justice Matopo, and it is a very serious concern.
But if the respondents say, wait until you hear how the DG is going to be exercising his or her functions, and your fears may be allayed. And in other words, they're saying you put in the cart before the horse. When the regulations come out in the wash, you will find that what you've been complaining about actually has no merit. Should we wait, or should we intervene as the High Court did right now?
The question whether the Director General and the Minister have excessive powers, the question whether the Minister is given the power to legislate, the question whether the DG can make decisions that infringe on rights because the Act empowers him to do so. Those are questions that have nothing to do with fears. They are questions that can be answered by reference to the provisions as they stand. It's not about fear, it's about power and what is conferred upon these functionaries. And that answers the question. That's why we say this is it's absolutely not an abstract challenge, because it's there, it's right there in the text of the Act.
All right, lastly, let's talk about remedy.
Yes.
How can these provisions be saved? One, do we strike out completely, or will there be any reading in? Secondly, or do we say to Parliament, we give you a period of time within which to come up with something that can be done to save it? Say, for example, we strike it out. The Act, is it your submission that the Act can remain as is, absent the impugned provisions?
Justice Matopo, this Act was passed into law in 2003. It came into operation in May of 2005. It has been in force for 20 years. For 20 years, there has been no need to bring it into operation. There was the brief attempt by former President Zuma, but then that was withdrawn, and then years passed again. Nothing has been done. So it is absolutely true that this Act can stand without these provisions. Severing them has no effect on the Act, and we are left, for example, with Chapter 3 that deals with norms and standards. We are left with everything else that is necessary to regulate the professions. So we say it can be severed. There is, in fact, no need to do anything else. We say also that the exercise of trying to read in is almost impossible. I thought about it. And I notice also that my learned friends for the Minister and the DG didn't offer anything themselves. They seemed to suggest if one section falls, all of them fall. And so there's no suggestion that I can engage with on how that might be done. If this court considers that a scheme, a certificate of need scheme, might be important for the transformative vision, if it is conceived that there is a way in which such a scheme might work constitutionally, it might refer the matter back to Parliament. We say it's not necessary, but of course that is something that lies in the hands of the state.
But where would our sources or our source be that this scheme should be referred to Parliament, that it can work? And on the face, if we are to reach a conclusion that the scheme as it stands intrudes and offends many of the constitutional rights, right? The ones that have been listed by the parties. If we are to arrive at that conclusion, is there any way that we could say, Parliament, have a look at it, have a look at the scheme?
Well, I suppose the better option would be for this court to strike out these sections as did the High Court. It is then open to Parliament to consider whether it wants to make an amendment to this Act, maybe introduce something else, because with the guidance of the analysis of this court, it can conceive of something. But it's not for this court to legislate.
No.
That we must accept. It can, at best, give guidance to Parliament. And whether Parliament yeah, whether Parliament still wants to, 20 years after the fact, impose such a certificate of need scheme, one doesn't know. It might look very different now, given the constitution of Parliament as it is now.
Okay, thank you.
Ms. Engelbrecht, you know, I get worried sometimes when a party comes here and says, strike it down and do nothing. Especially when that party, like the others, admit that or concede that there's a disparity in terms of access to adequate health care. That's what we are told. But we are also told, do nothing. Because I hear you say that. You say, strike them off and do nothing. But I just thought, let me just tell you that, especially the questions that Justice Kolapen asked you to say, these provisions have a transformative objective in them as to how you redistribute access to health care in South Africa.
Justice Mlambo, Deputy Chief Justice, you heard me answer Justice Matopo in this way, that
Yes.
It is possible to send it to Parliament. We don't raise a particular objection to it. The difficulty is to conceive of what it is that Parliament must do, and that is the question that Justice Matopo asks of me.
Well, we can't dictate to Parliament, can we?
And that is the difficulty. So the problem is not that my client is coming before this court and saying, you must strike something that has transformative vision and do nothing. The point is that Parliament, faced with the finding that the mechanism that it has put up does not pass constitutional muster, and that doesn't survive. It is open to Parliament then to conceive of another transformative measure. It doesn't mean it can't do anything, but it only means that this court isn't crafting legislation, as it were, for Parliament or directing it on what to do. And I have to reiterate this. I was here a number of years ago in a matter, and I made the point to the court. There's a Xhosa proverb that says, good parents can have bad children. We must be careful that the very important transformative goals aren't trampled on, that they don't yield bad children, because we just rely on a generalized transformative vision. It is important, because transformation is so important, it is essential that transformation and transformative objects be pursued in a structured and appropriately confined manner, so that it is not open to those who are anti-transformative to come and attack those provisions. It is essential. And so we can't just say something is transformative. We must say, how is the transformation achieved? And we say the certificate of need does not achieve the transformation.
Okay, no, thank you for that. And just to read, to clarify in my head, as you stand there and as you began your submissions, you represent the interests of service providers.
Yes.
Okay, I think that's clear. Just one last thing. In paragraph 17 of your written submissions, you mentioned that this scheme, the impugned provisions, over-centralizes control over the healthcare industry in the minister and the DG, and say this poses a risk of arbitrariness.
Yes.
Now, what I want to ask you is, can one really say that if one looks at the need to read these provisions in a constitutionally compliant manner, and to look at themselves to say, don't they have enough constraints that assure anyone that there'll be no arbitrariness?
Well, we submit, of course, that there aren't enough constraints. But I think in particular as regards paragraph 17 of our written submissions, there is a different layer, and a layer that I didn't really touch on very much today, and that is this question of the powers of the provinces, and the powers of local government in relation to healthcare services. And the point about centralization is we are talking about a certificate of need, that somewhere in Pretoria, a decision is being made about a certificate of need. What about the involvement of the provinces? What about the involvement of the districts? Is it not more appropriate, one asks hypothetically, that given the constitutional powers of the provinces and their involvement in health, and also the ability of the local and provincial governments to more effectively consider whether there is a need or not, is it then appropriate that there is centralization at national level? So that's really more what this concern is about in paragraph 17.
Okay. Thank you very much, Ms. Engelbrecht. Okay. That will be it for now. Mr. Leach?
As it pleases you.
So, excuse me. There's something that worries me. It relates to remedy. And striking out the debate that you had with me and also with the DCJ. Would it be correct, or would it be a correct approach, seeing that the regulations have not been promulgated, to say we strike out everything and if there is a need to reintroduce this certificate of need together with the regulations, it will be at that time. In other words, the respondents will have an opportunity to have a relook at the certificate and also the regulations that are foreshadowed and decide what they have to do. I'm not too sure whether it's a good question to you or it's just unfair.
Justice Matopo, I have to face all questions, fair or unfair, when I stand here. I think the concern about giving sections 36 to 40 a sort of a half-life, in other words, saying that they are struck, but they can somehow be revived once regulations are ready, would be problematic. I think the better approach is that if these provisions are struck, it is for the Health Department and the Minister to persuade Parliament to then adopt new provisions that are suitably tailored to take into account both the interests of the transformation of the industry and the individual rights, appropriately balanced, and when they are ready at that time to then seek to introduce that legislation and couple it with regulation.
Okay, thanks.
Very much, Mr. Engelbrecht.
Thank you, Deputy Chief Justice.
Mr. Leach?
Deputy Chief Justice, I see I have 20 minutes. Deputy Chief Justice, this court and our other courts have often said that of its many evils, one of apartheid's most pernicious was that it forced parents to make a choice between a job or being with their families. It was a Hobson's choice. It wasn't a real choice at all. But it damned parents to live apart, and it damned children to grow up without their parents. And that is the context in which sections of our Constitution have been formulated and framed so as to ensure that that right to live and work wherever you choose is a right that is protected and preserved. The question can be asked rhetorically: if before embarking on your career choice, you were faced with the prospect of having to make a choice in the future about whether you lived with your family or whether you pursued your career, what would that do in terms of impacting your choice of a career? And that's a question that is raised squarely in Haas's papers. It says in its papers, and it's not dealt with, very little of what Haas raises in its papers is dealt with in answer, and very little in what Haas raises in its papers is dealt with properly, if at all. Most of it is dealt with on the form of a bare denial. But Haas says that if you are faced with that choice now, as a young person embarking on a career, there's a very strong likelihood that you will not embark on that career. And understandably so. We've debated today, I say we, the court has with Ms. Engelbrecht, has debated today different contexts. The proposition has been put in different ways. What happens if there were lawyers who were sent to districts, remote districts, because of the need for access to justice? What would that mean? It's a question that can be asked across virtually every right, because it's not only access to health care that is one of the legacies of apartheid. Access to housing, access to jobs, access to food, access of all forms, including justice. These are all rights that have been implicated negatively in apartheid. And my submission to the court is that if this court is going to uphold the Certificate of Need provisions, then it has to make two conscious choices with respect. The one is that it has to say that the health profession is somehow special, and that the members of the health profession can be singled out for this treatment of geographical relocation at the behest of the Director General. The second choice, and the more fundamental choice that this court has to make, is with respect that telling people where they can live and where they can work is something that is justifiable, not only per se, but more importantly justifiable on the facts that are before this court. And that's where this problem falls apart, because it's for the respondents to say that on the facts before this court, that intrusion into the rights of individuals is justified and justifiable, and that it will meet the purpose. And they do not satisfy that. The reason why they don't satisfy it is because they don't put up facts. They don't put up evidence. Even their recourse to Certificate of Need provisions elsewhere in the world, they start off in addressing Haas's proposition that Certificate of Need provisions have not worked elsewhere by saying the United States is not a good example because it's a completely different scenario. going to try and make in the time available to me 5 points. The first of them is this. The definitions of health services are extraordinarily broad and include municipal health services. And those definitions read into sections 36(1)A, sections 36(1)B, and 36(1)D, because those definitions read into the definition of a health establishment and a health agency. A health establishment is defined under the Act with reference to the fact that it is a place where health services are provided. So whatever a health service is, and whatever that overbroad definition is, if that service is provided at any particular place or a part of a place, then that by definition is a health establishment. And the person who has that health establishment must therefore get a certificate of need. Equally, if anybody uses health technology, then that is also under the definition of health technology defined with reference to health services. It's any equipment that's used to provide health services. So they must get a certificate of need. And Haas's proposition is, and it brings this case not only on behalf of its members, but it brings this case inter alia on behalf of the members of the public, the members of the health profession that are associated with and work with its members' hospitals, with health care personnel or employees, and in the public interest as well as in the interests of its members. And that is not denied. That standing is noted in the answering affidavit, which, as I understand the law, means that it's admitted. So Haas's standing to represent all of those different interests is admitted before the court. And what Haas says to the court essentially is this: you cannot divorce the people from the health establishment. You cannot provide a health service. You cannot serve without a server. You cannot say theoretically or notionally or rhetorically or academically that you are going to require somebody to establish a health establishment in a place of the Director General's choosing without acknowledging that at the heart of that you are compelling the person who will provide the health service or persons to relocate to that place. So at the heart, because of the definitions, at the heart of this case, it's about every single person who wishes to provide health services potentially being brought within the ambit of the Act. And subsection C, which refers to prescribed health services, is an or. A, B, C, and D are conjunctively disjunctive through the or. So, yes, when prescribed health services are prescribed, there will be a greater net or a closing of a net, but that is not the whole point. The second point is that I wish to make to the court is that practically speaking, these provisions can have only two real purposes. The one is vis-à-vis people other than national health, but who are still within organs of state or public health. Because national health doesn't need permission from its Director General to set up an institution or a health establishment anywhere of its choosing. It can do that, and Haas says that one of the reasons why it's now trying to corral or cudgel private into doing it on its behalf is it's because the public has singularly failed the public health system to do that. After 30 years, as Justice Matopo said, after 30 years, health has gone backwards, not forward. That's the evidence on the affidavits of Haas which is met with bare denials. So, if the state is going to use the certificate of need provisions to compel local authorities or provincial authorities to provide access to health care, then that intrudes into the separation of scheduled powers under the Constitution, which is a point we've made. But Haase says that leaving that aside, the real import of the certificate of need provisions is to compel private people to move somewhere that they would not otherwise want to go and to do something on behalf of the public. And that's with respect where Haase's affidavit and the failure on the part of the department to answer that affidavit becomes crucial. Because Haase explains to the court what the decision-making processes are that go into establishing a health establishment. Whether that's a GP's practice that could cost somewhere between 500,000 or 3 million rand, or whether that is a health establishment like a hospital, which can cost somewhere between 500 million and 1 billion rand. Haase says that there are commercial decisions that have to go into that, and that makes sense. And that, with respect, is not challenged and it's not denied on the papers, other than for a bare denial. So Haase says, when the department is going to say to somebody, you must establish a health establishment somewhere where we choose it, if that party cannot satisfy the underlying requirements, the thinking process that goes into the decision of whether or not to do so, then whatever the health department tells them to do is ineffectual. And that's the reality. Because the Director General can send somebody to a rural village. But if that person goes to the rural village, whether it's to dispense access to justice or dispense access to health care or to build houses, if they go to that rural village but are not provenanced through an income that they can earn, then they are working for free because the government is not offering to pay them. So the second point is, then, can you force the private sector to undertake this requirement of meeting the government's obligations under Section 27 of the Constitution? But Haase says that that's only half of that debate. And the third point I wish to make is this. On the evidence before the court, and I know that I'm probably sounding, and I apologize to the justices, I'm sounding like a stuck record. But the Samu decision that Justice Matopo referred to earlier clearly establishes as a trite principle in paragraph 59 that it is evidence that the court will have regard to, not submissions. And Haase puts up that evidence, and it's not countered by other evidence that comes on the part of the respondents in their affidavits. And on the evidence before the court, Haase says quite unequivocally that these provisions, when they are implemented, and virtually from the moment they are implemented, will have a chilling effect and will have the opposite effect to promoting access to health care. They will reduce or diminish access to health care. And that is the case with respect on the evidence before the court that we must decide. So, Section 27.2 is not going to be enhanced through these provisions. The fourth point I wish to make is this. It is geographical location, and geographical location that is put up at various places in the answering affidavit as being the founding purpose of these provisions. It is not norms and standards. And the reason why I say that with respect is because there is an entirely separate department, the Office of Health Standards Compliance, that is tasked with enforcing norms and standards. The norms and standards are not set by the Director General. They are prescribed by the Minister acting on advice, not of the Director General, but of a commission. And under the health standards, the Office of Health Standards, under the office, if I can call it that, under that office, there are people who are appointed as health officers and inspectors under sections Section 80. And it's their role to ensure compliance with the Act and to ensure compliance with health standards. They are the people who are specifically tasked with investigating, inquiring into, and enforcing compliance with norms and standards. That is not the role that is assigned the Director General. And lest I be accused at a later date of ignoring a provision of Section 36, Section 36(6)(a) says that the Director General may withdraw a certificate of need on the recommendation of the Office of Standards Compliance in terms of Section 79(7)(b). That subsection has been deleted. Subsection 79 no longer makes provision for that, and the decision whether or not to withdraw permission for a private health establishment to operate no longer vests in the Director General, it vests in the Minister. So norms and standards are not what Section 36 is about. That is dealt with in an entirely separate section, and time precludes me, unfortunately, from going through the details of that, but Chapter 10, Section 77 and following, establishes the Health Office, the objects of which are to protect and promote the health and safety of users of health services by monitoring and enforcing compliance by both health establishment with norms and standards prescribed by the Minister in relation to the national health system. So whatever else these certificate of need provisions are about, they are not about upholding norms and standards. And if the Director General were to intrude into that realm, then with respect, our submission is that he would be acting ultra vires the provisions of the Act. So we come back then to the purpose of the Act. The purpose of the Act, sections 36 to 40, being to compel people by dint of removing their permission to live in one place to move to another place. And with the greatest of respect, that sounds to me very much like the Group Areas Act. You remove the consent of somebody to live in this place, and you tell them that you can only go and live and work in that place. And Justice Colopin, in asking questions of my learned friend Ms. Engelbrecht, spoke about ours being a transformative constitution. But this court in, I don't know how you pronounce it, whether it's Garvas or Garvas, but Satawu versus Garvas, I think it is. Satawu versus Garvas said, ours is a never again constitution. And this court has also, in the most recent judgment on housing, Chanel Commando versus City of Cape Town, Deputy Chief Justice, may I just finish this last submission? It's my fifth and final point. In Chanel Commando, which also referred to to Port Elizabeth Municipality and to Belisha Homes and Blue Moonlight, this court has repeatedly and consistently affirmed the principle of allowing people the dignity of letting them live where they want to choose, and the interrelationship between where they live and where they work, and how that also allows them to form communities. So if this court is going to find that the transformative obligations resting on the department under Section 27(2) is to trump all of the other rights, I'm sorry, that's a terrible use of that word, I shouldn't use it. If this court is going to find that that obligation under Section 27(2) allows the department to override all of the other myriad rights, then with respect, the court will be going against the foundational principles of other decisions which have asserted those rights as being of enormous importance in the lives and the dignity and the entitlements of people. Deputy Chief Justice, I strayed over my time, I apologize.
Thank you very much, Mr. Leach. I know we've debated this point with Ms. Engelbrecht, but I just want to hear you. The respondents, in essence, say your challenge is against an inchoate legislative arrangement. The scheme is still inchoate because the regulations in terms of which it will be implemented are not yet there. And the question that comes to mind is, why should we look at it now until these regulations come?
Deputy Chief Justice, can I answer your proposition in two ways? The first is a factual way, and the second is a principled way. From a factual point of view, Ms. Engelbrecht made the point, and I'm not going to repeat her submissions, but Ms. Engelbrecht made the point that the 2-year window period is not a window period that says when it expires, then you must apply for a license. It says when the 2-year window period ends, if you do not have a license, you're committing an unlawful offense under Section 40. HASA says that the implication of this, from a factual point of view, is that immediately the sections are introduced into law and become effective, there will be a risk that arises. And that risk is one that is going to implicate the funding of private hospitals, health establishments, including maintenance and future costing, decisions that are taken many years in advance. That evidence says that the risk will be such that capital will be moved elsewhere to less risky endeavors, or the capital will become more expensive to accommodate that risk. That's the evidence before the court. And what HASA has demonstrated, therefore, is that if we wait until the regulations, that's not good enough. Because once we're waiting for the regulations, we're still not forestalling the problem. Because when the risk eventuates, then the harm arises, including the diminution of the Section 27(2) rights. And the alternative to dealing with it now, from a practical and factual point of view, would be to have HASA come rushing back to this court once the regulations have been promulgated, or to the High Court for urgent relief. And that, with respect, is not feasible. The legal proposition, Deputy Chief Justice, is this one. I have formulated my address to the court on the basis that in deciding this case. The court is being asked at this stage to decide whether or not the scheme that has been proposed by the respondents, Department of Health and the Minister, whether or not that scheme has been shown to be a justifiable limitation on rights. And that scheme, the entire purpose of it, is geographical relocation. The answering affidavit is replete with instances of that. We've chosen only paragraph 114. I can give you, I counted them, there are about 20 references to geographical relocation in the answering affidavit as being the purpose of the scheme. So this court is being asked to determine a legal question, and the regulations cannot save that legal question. No matter what the regulations are that are promulgated, they cannot answer that legal question of whether or not the department has shown under the obligation that they bear in terms of Section 36, that their scheme is a justifiable limitation on rights. And one of the principal reasons why the department hasn't shown that is because they haven't dealt with the evidence that has been put up by HASA that shows that actually, rather than enhancing access to healthcare, this will diminish access to healthcare. I know that the court may be becoming tired of me repeating that, but it is crucial with respect, because HASA talks to the fact that we have a problem retaining allied healthcare professionals and healthcare professionals, including nurses. And HASA says that these people are being recruited internationally, particularly post-COVID. Those are the allegations. It runs for about 8 pages across HASA's founding affidavit. And in a 4-paragraph answer, the department says, well, you're relying on the hemorrhaging of health professionals report, which was 2007, and that is out of date. That's their answer. And then there's a bare denial. But they don't address the 2020 COVID epidemic. They don't address the 2022 report. They don't address the factual evidence that HASA puts up of how they are losing nurses on a constant basis to overseas and immigration. And what HASA says is that if you compel somebody to separate from their family and go and live somewhere else to pursue their profession, let's think notionally, if you'll forgive me for giving an analogy from the bar. I'm an advocate, obviously. My wife is a doctor. I might be subject to the Department of Justice's access. I might even have a Deputy Justice, Chief Justice, who requires me to go and undertake an acting stint. In that period of time, I will be absent from my home. I might be living in a different division. Might be living in Bloemfontein or Cape Town or in a labour court in Durban. My wife, on the other hand, might be sent to a rural village. Who looks after my children?
I think you're going back to your submissions that you've made.
Court pleases, Chief Justice.
But
I think I have tried to answer
you
your
have,
question.
yes. Let me ask you a different question. You admit or you concede that the provision of health or the access to adequate, affordable, timeless health care in South Africa is a problem. You make that concession in your written reply, in your written aids. Am I correct?
Yes, Chief Justice, I think that everybody understands and appreciates that that's a problem.
Yeah. And you,
Can I,
do you...
That's access through public health care.
Yes.
Because HASA says the private hospital sector and the private health sector free of, and I'm going to be blunt here, they say free of the corruption and the maladministration and the inefficiencies that beset and plague the public healthcare system, have stepped in to fill a gap. That's the evidence that HASA puts up. And they say it's not a case of a failing of private healthcare, it's a case of failing of public healthcare.
I see. So, do you understand then you to be saying the role of the minister in regulating healthcare is very limited when it comes to private healthcare providers?
Not at all, Deputy Chief Justice. Regulation of any industry is permissible, both under the Constitution and more generally.
No, but if you agree that the minister does have the power to regulate that, you can't seek to differentiate between public and private healthcare, can you?
No, Chief Justice, the question, I apologize, Deputy Chief Justice, the question that was put to me is whether or not HASA, my client,
Yes,
concedes that access to healthcare is a problem.
yes.
And HASA in its papers says quite clearly the private healthcare system is a very good and functional system. There is a real problem in access to healthcare in public healthcare. That's where the problem lies, says HASA. Now, the proposition that you, with respect, the Deputy Chief Justice, have now tagged on to that is, does that not mean that the minister can regulate both public and private? Yes, of course the minister can. But that doesn't solve the question or answer the question of whether or not there is a problem in access to public health care or health care more generally. Those are different propositions.
Yeah. Look, I'll leave it there because, you see, the sense I'm getting is an attitude that's being given to this court to say those who can afford and who are privileged should not be touched.
No, Deputy Chief Justice, that's not, with the greatest of respect, if that's the impression that I'm conveying, then that's not the intended impression that I wish to convey, because it's also not the impression that HASA conveys, because HASA talks to how, in its papers, it talks to how, in times of need, including during the COVID crisis, its members have stepped up. It also talks to how its members provide emergency medical care when there's a time of need. HASA is not unsympathetic. But the question that you're putting to me, Deputy Chief Justice, is not one of sympathies. The question is whether or not the minister can, under the auspices of regulation, compel a private citizen to move somewhere and do something without anything more, without paying them, without offering to pay them, without employing them, without doing anything more. That's the proposition. And HASA says that idea is not an idea that comports to regulation of the healthcare system. That's something different. But within that, they're very sympathetic about the lack of access.
Thank you very much. Thank you. Questions?
Mr. Leach, I have listened with interest to the argument around Hobson's choice between career and family. But what troubles me, and also to your response to the Deputy Chief Justice around the public responsibility, the Section 27 right to ensure greater access to health care. But what troubles me is the balancing between these different issues, because what comes across, and correct me if I'm wrong, is something of a sense of that bluntly this isn't our problem, and that we have, if you can afford it, you get good health care in this country, in fact first world health care, to the extent that foreigners are coming to access that health care. and we can't provide for our own people. But if we look at cities like Cape Town, at Groote Schuur you wait 9 months for an MRI brain scan. If you have a child with a brain tumor, you must wait 9 months. If you have access to private healthcare in the city of Cape Town, you can access a brain scan today or tomorrow because it's urgent. That's not the same if you can't pay for it. And so that poses some very real balancing issues that are of concern that one needs to look at. And it seems to me that on the one hand, that if we look at the provisions in question, that we're trying to debate whether we can share resources. We're trying to see how we can best share resources and ensure that our citizens and the people in our country have access to proper health care. Whether you're a woman with breast cancer in the Eastern Cape or a woman in Johannesburg with breast cancer, whether you're a child of 10 with a brain tumor in the Eastern Cape or in Limpopo province, or whether you're a child with a brain tumor in Johannesburg or Cape Town. So my question really is, are there less restrictive means that you would suggest? Is it really a question that this is too restrictive, that we understand the government purpose being to ensure that there's an equitable distribution of resources, that there's some sharing of resources? And is it from your perspective that there are less restrictive means to achieve this? Because left purely to the private sector, we're sitting 30 years later where we have a greater and greater disparity between what's available and what's not.
Justice Savage, can I answer the question in 2 ways again, if I may? The first, because with respect, there really are 2 different questions. The first question that's being put to me is whether or not there is a potential for sharing of resources. The second question is whether or not there's a less intrusive way of achieving what the Certificate of Need provisions try to achieve. The second question is an easier question to answer, because what the affidavits show is that once you have tertiary hospitals in city centres, which is where you have a concentration of people and where the people who are most likely to be the nurses and the doctors are residing, ordinarily resident, so that they can staff those hospitals. And in circumstances where all of the resources, the supply technicians, the servicemen, service people, where all of those resources are readily available, they say it makes sense to urbanize. It makes sense to urbanize that type of resource and to allow people to come in, and that the money would be better spent, as HASA says its members do, on ambulatory and transport services, where you're then better able to efficiently utilize the resource in question. So HASA says there are better ways of doing it than forcing people to go somewhere else, to set up a hospital. They say the better way of doing it is to allow the hospitals to be developed where they should be, where economically they can be and where they're sustainable, and then to allow people to come into those hospitals. And the same thing with respect, I heard Justice Matopo talking about his experience in his village, where there was one doctor who came once a week. If a doctor could sustain a living in a village, then I have no doubt the doctor would come more than once a week. But if the doctor cannot do so, and that type of interaction where private facilities have outreach programs that train for the blind, that does the cataract surgeries and travels around, that type of facility is better. It's a less intrusive way than forcing somebody to go and live in a village. But the second question is the more difficult one. The second question that was put to me, Justice Savage, is how do we share resources? How do we share resources between public and private? And the answer to that question is, I don't know, except to say that section 36 to 40 has got nothing to do with sharing of private and public resources. There is nothing in sections 36 to 40 that talks to a way in which the private sector can be made to bring in people or to expend resources on people who are otherwise indigent. There's nothing in sections 36 to 40 that talks to how the private sector should be allowed or should even be obliged to make an MRI machine available to a child with a brain tumor rather than having to wait for 9 months. That is absent from sections 36 to 40.
Can I interrupt you there? I mean, perhaps it's not. I mean, if a certificate of need were to be issued in respect, for instance, of that sort of specialized machinery, then why have 20 of them in a small geographical area and none available in another province, for instance?
Well, because, Mr. Savage, and I'm sorry again to refer to it, but the unchallenged evidence before the court is that preventing somebody from having a machine in Johannesburg is not going to mean that a machine will pop up in a rural village somewhere else. Apart from anything else, you've got to be able to get the machine there. You've got to be able to service the machine. You've got to have a radiologist. You've got to have a radiographer. You've got to have nuclear containment facilities for an MRI machine. All of those things are things that HASA says, if you require us to put those up, we're not going to because we cannot.
Thank you.
Mr. Leach, I had the debate you had with my sister. You know what worries me is what she has alluded to, the contestation between the resources. I just don't know how this can be resolved, because one cannot shy away or move away from the fact that the elephant in the room is that our health system, it's failing or has failed. Whether the certificate of need is the necessary panacea to resolve it, I don't know. Whether transfer of resources to those far-flung remote areas can help, as the government says, may be good, may not be good. But sitting as I am here, it's difficult for me to shrug my shoulders and say, because people in the city center or in the urban areas have access to those resources, they're better off than the people in the far-flung areas. I don't think that's what that's the submission you're making. Am I correct?
What I'm making. Justice Matopo, I'm not making that submission. I'm not submitting to this court, and I would never make that submission to this court, that I'm all right, Jack, you can look after yourself. That's not the proposition. But with respect, pregnant within the proposition that you did put to me, Justice Matopo, is the answer to the conundrum that the court is facing. And it also lies in the proposition that Justice Savage put to me, because both those questions or propositions are concerned about resources. What we're concerned about when we talk about resources is we're concerned about things like hospital beds. We're concerned about things like MRI machines. We're concerned about things like access to medications. And being in a rural area or being in an urban area doesn't necessarily mean that we have access to resources. And having a concentration of resources in one area doesn't mean that all of the people in that area have access to those resources. But what the certificate of need provisions try and do is they don't try and divvy up the resources. They don't try and make private use its resources in the expenditure of satisfying access to need. What the certificate of need provisions do, and that was why I started with the definition and how it relates to health services, is it tries to take people and it tries to socially engineer where people must be.
So, sorry to interrupt you. If you take the situation in Johannesburg, in Gauteng, for example, we have many hospitals, and those hospitals are ill-equipped. And I'm just thinking about whether we need to relocate people elsewhere. The people in Johannesburg would say, we need those services here. If you go to Chris Hani Hospital or go to Tembisa Hospital, there is a complete failure of any health facilities. We are also suffering. Now, what I don't understand is, or what I need clarification on is, if that certificate is to be implemented, let's locate it in Johannesburg, in Gauteng, for example. Baragwanath Hospital, the situation there is dire. You go there, you don't come back alive, if you're lucky. And the problem is, could one say the problem is the certificate of need would resolve the problem, or the problem would be the resources? And if it is the resources, then as government, we are probably not doing enough to address those resource issues to try and ameliorate the problems that the people are facing on the ground. And if that is the issue, then the certificate will not even help at all. Will it help?
Justice Matopo, with the greatest of respect, that is absolutely correct. The department has not shown in its 100-odd pages of answering affidavit and annexures, the department has not shown how the certificate of need provisions will address that question of resources and the lack of resources in public healthcare facilities. Because even if the Mill Park Hospital is refused permission to install an MRI machine, that doesn't mean that Netcare, who are the owners of the Mill Park Hospital, will install an MRI machine in Baragwanath Hospital. That's not what the certificate of need provisions provide for.
Well, let's just forget about Mill Park Netcare. Let's look at what government ought to do apart from Netcare and what government has done or has not done. If Baragwanath Hospital runs or does not have the MRI scan, will the blame be laid at the door of Netcare, or is the blame be laid at the door of the government for its failure to address these core problems that as a people we don't have those resources? And why don't we have those resources? Are the funds properly allocated to cater for those exigencies, apart from what private sector would do? As a government, have we done enough?
Justice Matopo, with respect, the allegations that are made in Haas's founding affidavit are that government hasn't done enough. But let's assume, for present purposes, that government has maxed out its resources. Let's assume that they've efficiently utilized all of their resources and that the simple truth of the matter is that the piggy bank has run dry. Let's accept that. It still doesn't answer the question of how refusing a certificate of need to somebody else in Johannesburg is going to solve that problem at Baragwanath. And that's where we seem to be passing one another like ships in the night. Because the respondents are saying, by refusing a certificate of need, or by the Director General looking at the 13 items in Section 36(3), by the Director General looking at those and geographically relocating private individuals, we will solve that problem. And everybody's going, how? It's not a facetious question. It's a question that says, how? How does this address the problem? And there is no answer to that in the department's answering affidavits. So when the 8 applicants say to the department and say to this court that what you're really proposing to do is ride roughshod over numerous rights in the constitution of individuals, but you can't demonstrate to me how that's going to solve any of the problems. And you can't demonstrate to me how, by refusing a hospital in Johannesburg, a hospital's magically going to spring up in an uneconomically viable area in the northern province. Then why are we having this debate? Why are we having the debate, says Hasa and the other 7 applicants, when you need to show us how this is going to work? That was why I took the court in my initial address to Chapter 10, because it's not a norms and standards thing. The health professions are regulated, and the proposition was raised earlier about, I think it might have been Justice Tehran who asked about the Legal Practice Council. The health professions are regulated by their own custos mori. They are the people who sit and look at whether or not a doctor has misconducted herself. As the court pleases, Justice Matopo.
Just a follow-up, Mr. Leach, on the public-private relationship. Does the scheme as it's conceived now not make express provision in Section 36 to public-private partnerships? I mean, could that not be one of the intentions of the certificate of need? To say, for instance, take your MRI machine that we're speaking of in Grooteskier, I mean, let's say in Millpark, let's use a Joburg example, in Millpark, and share it with Tembisa Hospital. Have patients from Tembisa come here. That's the basis on which the certificate of need will be issued.
Savage, if only that was what the section said. But the section doesn't say that. The section says that the Director General must take into account the 13 items in Section 36(3), and public-private partnership is not there. And then in Section 36(5) says that the Director General may impose a condition. So first the Director General has to determine and
under 5, it does make reference to any condition regarding public-private partnership.
Yes, that's what I'm saying to you, Justice Savage, is that the Director General can impose a condition, but the exercise is one that first requires the Director General to go through the Section 36(3) process. That is the determination. The question was asked earlier, I think it was Justice Majid or Justice Collopin was asked earlier of Ms. Engelbrecht about a PAGA process. And with respect to Ms. Engelbrecht, she quite rightly said that if the Director General started under the auspices of looking at the issuing of a certificate of need or the renewal of a certificate of need, started looking at private interests of a person, they would be acting ultra vires the requirements of Section 36(3). Equally, if under Section 36.3 the Director General started to look at public-private relationships, then that's not one of the features of Section 36.3. He would first have to go through the 36.3 process and then potentially would be entitled to impose a condition. But the harm is what lies in 36.3 and Sections 36.1 and 2. If you'll bear with me a moment, please. I apologize. I hope that's answered your proposition, Justice Savage.
Thank you, Mr. Leach. Just one or two questions from my side. When you speak of compulsion, are you referring to, in a sense, the default position that a healthcare professional may apply for a certificate of need? The director can either grant it or refuse it, correct?
Indeed.
The director can't say, in refusing it, I direct that you go to Mabopane, for example. There's no provision for that.
There isn't any provision.
You're referring to the default position where perhaps there may well be a list of areas that are underserviced, for example, and it'll be clear to the healthcare professional, look, if I apply for a certificate of need in Parktown, I'm unlikely to get it. But if I apply, for example, in Diepsloot, I'm likely to get it. I mean, we don't know how this is going to work in practice, but the point I simply wish to make, when you speak of compulsion, it's not as if anybody can be compelled to go to a particular area. They may do so when their certificate of need is refused and they apply for a new one.
Well, Justice Colopin, my submission in answer to the question that you've put to me is that, forgive me if I can go back 3 steps, and I'm going to use.
Sorry, I just want to understand.
Yes,
your understanding of Section 36 is that you would apply for a certificate of need, and it would be for a particular geographical area. Let's say you would say, I want to practice in Parktown.
I was going to answer that question, Justice Colopin. But
I'm just mindful of the time, Mr. Leacher.
Let's, because we can postulate a hypothetical situation here. Let's postulate somebody who grew up in Johannesburg. They grew up, they went to school at Parktown Boys High School. They went to Wits University. They did their internship at Charlotte Maxeke Academic Hospital, and they did their community.
Mr. Leach, let's accept all of that in a sense, because I just want to get to my understanding of the legal position,
I'm getting
not of the person behind it.
I'm getting to that, Justice Colopin, because when that person applies at the end of their 9 years and says, I want to establish a health establishment as a general practitioner in this area, and is refused that certificate, then the person has only one choice, absent giving up medicine, and that's to travel to another area.
Sure.
Because if they persist...
No, I think you've answered my question.
But Justice Colopin, there's an important proviso to this, which is Section 40. It's not an idle threat. There is a criminal sanction involved. That's where the compulsion lies.
Sure, but and maybe we're talking at cross purposes. I'm simply putting the proposition to you that if your certificate of need application is refused, right, then you have a choice to either go to another area or not. And that's where you say the compulsion comes in. Maybe a matter of words, but I'm simply putting to you that under no circumstances can the Director General say to somebody, you will go to Area A. That's certainly not what is contemplated.
And Justice Colopin, may I say this, that if the Director General were to be afforded the powers to direct a private citizen to go somewhere.
But that's not
No, I understand
case.
that. If they were afforded that power to direct somebody to go somewhere, that would clearly be unconstitutional.
Sure, I accept that. But I'm just asking you, Mr. Leach, that in your argument, you suggested that someone is then compelled to go and open a practice where they don't want to, they're directed to do so, and that's simply not my understanding of the law, but it may work by default.
But
Maybe we should leave it at that.
Justice Colopin, that's the very proposition, that the Director General is achieving what he couldn't do explicitly by a default proposition of refusing a permission here.
Sure, but you're saying they won't, because there's no evidence that the refusal will result in that practitioner going there, so they won't achieve it. I mean, that's your argument, not?
Well, Hauser says that there are three potential opportunities. Either the person is forced to relocate to a place of the Director General's choosing, or the person gives up their career in providing health services,
Okay.
or the person immigrates.
Okay.
And Hauser says that if there's a likelihood of either the person giving up their career in health services or emigrating, then that is not good for access to healthcare generally.
And just lastly, Mr. Leach, I think we've been debating with regard to how, in a sense, the obligation of the state to make good on its constitutional commitments can sometimes be married by working with the private sector. And we were grappling to find examples. But there may be a very useful example in what is called sort of mandatory or inclusive housing. And inclusive housing proceeds on the basis that a developer can obtain permission to undertake a development, provided that it undertakes to allocate a certain portion of that development for affordable housing. Now that on the face of it intrudes into the developer's right to property, because the developer is compelled to, as it were, structure the development in a way that has a component for affordable housing. And there may well be an incentive, but it's not being suggested that the absence of an incentive would render that scheme unconstitutional. But there's simply an example, and I just raise it in the context of perhaps a sentiment that may be emerging in these proceedings that, well, government, that's your responsibility, which you can't foist on the private sector. And I'm just saying there are innovative ways in which, in a sense, this constitutional division of labor, if I could call it, is shared, mindful of private property interest, but is shared in the spirit of the Constitution, and that's one example of that. Yeah.
Mrs. Colopin, if I may answer that. I think, with the greatest of respect, what the proposition that you've put to me shows is that there may well be other alternatives. It's not an alternative that resides in sections 36 to 40 of the Healthcare Act, but there may well be other alternatives. HASA put up an alternative. The department has not put up any alternatives. It simply says there are no alternatives. But there clearly are, and there clearly may well be. But this court doesn't legislate. And the difficulty is that HASA, I beg your pardon, the difficulty is that the department is putting the court in the position of all or nothing, the binary choice. Because the department has not come to the court and said, if you take this portion out of the sections 36 to 40, you can save them. If you allow us to amend that portion, we can save them. Or if you read this in, you can save it. The department has gone for an all or nothing approach. That's the case that we have to meet. And as with the greatest of respect to this court, I understand and I sympathize with the difficult task that the court faces of having to say that the transformation of healthcare is not something that can be achieved by sections 36 to 40, and therefore we're constrained to strike it down. But it's the department that has put the court in that position, not the applicants.
Thank you.
Court pleases. I apologize for intruding into the lunch hour, Deputy Chief Justice, and I thank the court for entertaining me.
It's a lot. But we'll be there, we'll get there. I'm just going to No, they said we're taking 1 hour.
Good afternoon once more. Let us be ready. We are about to start. Thank you.
Mr. Manager, I think it's your turn.
Thank you, Chief Justice, Justices of the Court. I shall address 4 topics. I'll deal with the purpose of the Certificate of Need, the proper interpretation of the Certificate of Need provisions, whether the provisions are impermissibly vague, irrational, and constitute an impermissible delegation of legislative powers. Then I'll deal with whether the provisions unjustifiably breach constitutional rights. And my learned friend, Ms. Chabedi, will address the question of justification under Section 36 of the Constitution and appropriate remedy. I can say at the outset that we'll not be seeking a cost order, so that in the heads can be forgotten. So I will take 20 minutes of the prescribed time, and Ms. Chabedi will take 10 minutes.
Okay.
And hopefully there might be injury time, but that's the distribution. Starting with the purpose of the, I'll call them the CON provisions for short. The starting point is Section 27, which is that the state has a constitutional duty to comply with the obligations imposed on it by Section 27 of the Constitution. This includes...
Just raise your voice.
My voice.
Like,
Thank you, Chief Justice. I was saying the starting point is Section 27, which imposes duties, constitutional duties on the state, and those obligations include those in Section 27(2), which is to take reasonable measures, reasonable legislative and other measures within its available resources to achieve the progressive realization of each of the rights in Section 27(1). And the National Health Act we submit with the Certificate of Need provisions constitute the reasonable legislative measures that the state has taken in compliance with Section 27(2). And going to the National Health Act itself, it starts off in the preamble by recognizing the iniquities of health services of the past, which still persist, and states that the NHI intends, amongst others, to do the following, and I'm only referring to some of them. A, unite the various elements of the national health system. And the NHI defines the national health system to include both the public and private sector in a common goal to actively promote and improve the national health system in South Africa. That's the first point. The second is to promote a spirit of cooperation and shared responsibility among public and private health professionals and providers and other relevant sectors within the context of the national, provincial, and district health plans. And both Solidarity and HASA do not take issue with these objectives of the National Health Act. In fact, at paragraph 37 of its heads of argument, HASA embraces these objectives. And to demonstrate that these problems persist, HASA refers to an article published in May 2019, it's Annex HA16. The court will find it at HASA Founding Affidavit, Volume 5, page 377. And that states the simple fact that about 84% of the population in South Africa depend upon the public health sector. About 16% belong to medical schemes and depend on the private health sector. The 16% belonging to medical schemes consume about 50% of the total health expenditure in South Africa, and the 84% consume the remaining 50%, and also highlights the unequal distribution of healthcare workers and resources between public and private sectors and between urban and rural areas. And the affidavits show that not much has changed since that article in 2019. But instead of maintaining what the applicants want to maintain, the NHI does not, because in Section 2, where it sets out the NHI's objects, NHA, not NHI, I beg your pardon, NHA, the National Health Act, those objects include to regulate national health and to provide uniformity in respect of health services across the nation by establishing a health system which A, encompasses public and private providers of health services, and provides in an equitable manner the population of South Africa with the best possible health services that available resources can afford, i.e. equity and stability. And that speaks to geographic distribution and take into account that health services are localized services, so that when a person is in an inpatient public hospital is admitted, they require support from family, and so generally health services must be provided within a more convenient proximity and not 200 kilometers away, as was suggested. You could have somebody from Zanin come to Johannesburg because there's a concentration of health facilities here. And we submit that these objects, both of Section 27.2 and the National Health Act, permit the state to adopt a measure such as the Certificate of Need provisions as a legislative measure to achieve their objects progressively, i.e. the achievement of equitable distribution of the best possible health services in the national health system across the nation. And that, we submit, is the main purpose of the Certificate of Need provision, which is equitable distribution and equity in providing as best as possible medical services. And quality is achieved by maintaining norms and standards. And here we submit the applicants misconstrue the limited reach of Section 91C, which allows the minister to make regulations regarding norms and standards. Those in 91C relate to protective equipment and do not exclude that the Certificate of Need can be aimed principally at the equitable distribution, but also at ensuring quality, which is what they secondarily actually seek to achieve. So that's the purpose, and I tend to the proper interpretation of those provisions. And we submit with great respect that much of the attacks against the CON provisions stem from their incorrect interpretation. And that interpretation of the Certificate of Need provisions must be undertaken in the context of Section 27.2, bearing in mind the court's obligations under Section 39.2 of the Constitution, which is to interpret statutory provisions as much as possible to promote the achievement of rights or the protection of rights. And turning to those provisions specifically, one must start from Section 35 of the National Health Act, because that section makes it clear that the private health establishments are not all for profit. They may be classified either for profit or not for profit, and that comes from Section 35A, Roman 6 of the National Health Act. And so one mustn't lose sight of the fact when one assesses whether there is a rational connection between the purpose to be achieved and the provisions, that you're not only dealing with profit motive owners of health establishments, such as hospitals, you're also dealing with non-profit organizations which deliver private health services. The first observation we make is that the applicant attacked the scheme as a whole. That's how they frame their attack, but the thrust of that attack is on Section 36. And we submit that that's for good reason, because there is nothing constitutionally offensive with certain of the provisions of 36 to 40. And I take, for instance, Section 37, which deals with the question of limited duration. There's nothing constitutionally offensive with a licensing provision or regulatory measure providing for a limited duration for permission that you need to renew or that it may be withdrawn. Generally, that's nothing constitutionally offensive with that. Section 38 provides for an internal remedy by way of an appeal in the event that the DG's decision is adverse to your interest and you need to challenge it. There's nothing constitutionally offensive about that provision. Then there's the power to make regulations relating to anything about the Certificate of Needs in Section 39. There's nothing equally offensive about that, because that regulating making power will be limited by the purposes of the National Health Act and the CON provisions. So it's not just to make regulations on anything you wish to make. And There's also nothing objectionable in requiring that if you don't comply with the requirement for a certificate of need, but you practice without it, that's a criminal offense. None of those provisions we submit offend the Constitution in any fashion. And the section 172(1)(a) of the Constitution only allows the court to declare a provision invalid to the extent of its inconsistency with the Constitution. So there is no basis on which the court can declare section 37, 38, 39, and 40 simply because a scheme is attacked, even though those don't offend the Constitution. Then I turn to section 36, which is the center of the attack. One must understand what section 36 deals with, and once one does that, you will see that a lot of those provisions are not constitutionally objectionable. 36(1) identifies who requires to apply for a certificate of need. So it's the provisions A to D. And then subsection B deals with how to apply for a certificate of need. Subsection 2, not B. How to apply for a certificate of need. There was an issue raised by Justice Teron about how one would apply. That will be prescribed because that's what section 36(2) says. It's you will apply in a manner prescribed by regulation. That regulation will tell you if there's an invitation to apply, what information is required, and so on. So one would imagine when you're applying for an establishment of a health facility in a township next to Soweto, and you want to take advantage of the congestion in Baragwanath Hospital, that you can relieve by the congestion if an outpatient facility, for instance, is established in a nearby township. The department is able to identify areas where it's necessary to establish health facilities in order, for instance, to relieve congestion in an institution like Baragwanath. And if you're an applicant, you would motivate in your application with relevant information to show that your application meets all of the criteria for establishing of a health facility in that area. And somebody might want to invest in that facility, may not be the HASA members, but there are many other private hospitals. There's a network of independent hospital groups that are not affiliated to the three dominant groups. Those might want to apply. Then sub 3 is the factors. I'll come back to the factors. Sub 4 is the DG's power to investigate and obtain information on any issue related to an application for a certificate of need. There's a suggestion that the DG is at large to investigate whatever he wishes to investigate, but that's not so, because the jurisprudence of this court in affordable medicines from paragraphs 35 to 39 makes it clear that a power stated in this fashion is limited by the purposes of the statute, by the purposes of the CON provisions themselves, so that the investigation by the DG to obtain information is to obtain information relevant to the achievement of the purposes of the legislation and not willy-nilly anything. Then 5 deals with the power to renew or issue or renew a CON subject to conditions. Now, one of those conditions that has been highlighted, the concept of renewal on its own is not constitutionally offensive. Almost every legislation that provides for permission, for registration, and in this case for certification, also has provision for renewal, because there must be an investigation to see that you still meet the requirements, you're still good for the purpose, and you must carry on. What was mentioned is was the PPP provision, and a suggestion, in fact, the High Court went as far as to say that a PPP is an expropriation of property. But that's a complete misunderstanding of what a PP is. But firstly, Section 45 of the National Health Act says that the minister deals with the relationship between public and private health establishments. And it says in subsection 1, the minister must prescribe mechanisms to enable a coordinated relationship between private and public health establishments in the delivery of health services, and says an agreement contemplated, there must be an agreement in sub 2, and that agreement must comply with the PFMA. The PFMA regulates PPPs, and PPPs are where, let's take the problem with Baragwanath, because Justice Matopo quite rightly pointed to it. There may be a problem of management at Baragwanath. managing facilities, managing resources. In a PPP, a private party is given the right to control a public institution or utilize a public institution for benefit, but for the benefit of the public, and they get paid a benefit. So they are doing it for the public, but really it's for your pocket. The Gautrain is one simple example. Bombela manages the Gautrain, runs the Gautrain for all of us as a public institution, and they get paid a benefit from what they derive from there. So it's not expropriating from the private sector, you're giving a private sector a business opportunity. That's how the High Court went so far from what the law is in that regard with respect. And Section 36(6) is the withdrawal provision. If the court looks at those provisions, the High Court found those provisions to be offensive. None of those provisions are offensive in themselves as a basis on which the certificate may be withdrawn. When you look at them, is on the recommendation of the Office of Standards Compliance, so you're not complying with standards. Continued operation of the establishment may constitute a serious risk to public health. That's B. C, you're unwilling to comply with minimum operational standards. D, if you're obstructing the achievement of access to healthcare under Section 27(2). So those are legitimate. So there's nothing wrong with that. And then there's a duty to give reasons under 36(7). That can never be objectionable. And then, of course, there is the Section 5 of PAGA also requires reasons to be given while they are requested. So there's nothing objectionable in that scheme. I look at then the section 36(3), which is then the provision that is left. The first challenge is that it is void for vagueness. With respect, on the standard that the law does not require perfect lucidity but reasonable certainty, you will look at A, B, and D and see that they are clear as to what they require. Then C, they say, well, C is vague because it says these prescribed health services are still to be prescribed by regulation. We submit with respect. The composite concept is not defined, prescribed national health, but its constituent parts are described. So prescribed, you know, is prescribed by regulation. National health services are all described. So out of the universe of all of the health services that are in the National Health Act, the minister will say a subset is prescribed for purposes of regulation 36(1)(c). There's nothing constitutionally offensive. That is the classic way of Parliament delegating subordinate lawmaking power, allowing the detail to be filled up by the executive. That's precisely what has happened here. And it's not a discretionary matter. I think the question was raised, and Justice Chiti said she would ask me whether the minister has discretion on whether to make regulations on that section. There is no discretion. It's a discretion coupled with a duty. Why I say that is because until those regulations are made, the Act, that section cannot be put in force. In fact, Section 91A of the National Health Act, which provides for regulation-making powers, says the minister may make regulations regarding anything which may or must be prescribed in terms of the Act. So it caters for both wholly discretionary and where it is both a duty and a discretion. So there is a duty here to prescribe those regulations and to list the health services prescribed. And Section 36(3), which lists the factors, is not impermissibly vague. The High Court's finding against Section 36(3), and the argument that was made before the court was the section is under-inclusive. And the court will see, I don't have the paragraph now, I'll come to the paragraph number. It's actually in paragraph page, in volume 11, page 904. I omitted to put the paragraph number, but you see that the court finds that what is wrong with the Section 36.3 is not what is there, is what is lacking. And what was lacking, according to the court, is the interests of the applicants are not taken into account, listed as a factor, and the dealing with concentration of facilities is not also listed. We submit with respect that that is an error in interpretation, because the provisions of Section 36.3 must be read subject to PAGA, and perhaps I'm now moving on to the rationality debate, and let me move there and deal with that concept under that point. So, leaving the vagueness point, our submission is not vague. All of the provisions are clear. There may be an issue, and the issues raised about rationality, which is what I moved to. I think I'm over my time, the 20 minutes. On rationality, the court knows that rationality sets a low threshold. What you're asking for is whether there's a rational connection between means and ends. There must be a rational nexus between the legislative scheme and the pursuit of a legitimate governmental purpose. And here, you're not looking to see whether the department has proved that the CON scheme is going to achieve the purpose. They're not required to prove with certainty that the scheme is going to achieve the purpose. What they need to prove is that the purpose identified, that the measures have a likelihood or may achieve the purposes, because one must acknowledge that the scheme might fail for various other reasons, one of which is how complex our healthcare problem is in South Africa. It's not one that is going to be resolved by a magic wand through a CON scheme. A CON scheme will just be one of the measures for intervention. So that does not mean that the scheme is not rational. And so looking at the factors in Section 36.3, the question the court will ask is, are those factors rationally related to the purpose for which the CON is designed? Do they help in achieving the purpose? And we make two submissions. They do, and secondly, they also cater for the interests of the applicants. And I start on the first factor is consistency of health services development. I've referred you to the article which shows these disparate development, inequitable development of health services, so that's a relevant factor. The second B is equitable distribution of health services and resources. That factor is relevant, it's clearly relevant, and it's broad enough to also look at the converse, which is over-concentration. When you're looking at equitable distribution, you're looking at over-concentration. So the argument that over-concentration is not mentioned is really not properly interpreting B. Then C is appropriate mix of public and private services, because you want to think about sharing, PPEs, all of those things, that's important. The demographics and disease profile of the population to be served. It will inform you what kind of facility you require for that population. Advantages and disadvantages to existing public and private health services and affected communities if the CON is granted. You've heard about this is going to affect competition. So if you're going to introduce a new facility in an area, it's a relevant factor whether it's going to affect the competitiveness of the existing facilities. That was E. I don't know what F went to in my... Oh, F is employment equity. So we accept grudgingly that that might not be directly relevant, but it's legitimate to ask whether the applicant's policies and human resource allocation is going to advance the objects of Section 9.2 of the Constitution. G is improvement of health services delivery from research. That's relevant. Ensuring no perverse incentive from ownership of health facilities. You're looking at it from the applicant's point of view. Is this going to create, what's the ownership structure? Are the doctors going to own this hospital? What about perverse incentives to overservice for them to make more money? I, the quality of past health services by the applicant. That's, again, the interest of the applicant. financial sustainability of the health establishment or agency, you're looking at the applicant's financial sustainability, ensuring availability and appropriate utilization of human resources and health technology. That's from the point of view of the applicant. Whether the health establishment is for profit or not for profit, that is from the applicant's perspective. Compliance with requirements of a certificate of non-compliance, that is from the applicant's perspective. So the applicant's factors relevant to the applicant are included, but there's an overriding obligation because you've got to read those sections subject to Section 33 of the Constitution and PAGA. And why do I say this? Because this court has said in Joseph's, in paragraphs 23 and paragraph 44 to 46, that even if a provision is silent about the right to be heard, if your decision is going to affect their rights and legitimate expectations, they must be heard. They must be given notice. They must be given an opportunity to make representations. So you can imagine in their representations, they'll say, this facility is most suited for this area. There is a need in this area, and we need a bed capacity, an additional bed capacity of 200 in this, and the public sector can't provide for that. We want to establish a facility there. The DG has to apply his mind to that or her mind to that, and he's got no carte blanche. He's bound by the Constitution to make that determination, both rationally, following a fair process, and a rational process, and not breaching constitutional rights. Those constraints are there, but they are overlooked. And those are emphasized also in affordable medicines, especially in the context of conditions, and I'll refer to that in the context of conditions. So we submit with respect that there is no under-inclusion. But anyway, an under-inclusion doesn't mean you strike out 36.3 as a whole. You ask Parliament to add, not to strike out the existing, because the existing is not offensive. In fact, the High Court says there is no quarrel with the contents of Section 36.3. But the quarrel is what is not in Section 36.3. So we submit that all of those factors are rationally related to the purpose of the con scheme, and the con scheme itself is rational in the sense that it has the capacity to achieve, not it will achieve the outcome. And the court raised the question, and I think it was Justice Teron, is there evidence in the answering affidavit addressing that issue? So the reality is the con hasn't been implemented, so you can't have real evidence that we have a pilot project and here it is, it can work. But what the state did is to investigate in jurisdictions where they have certificate of needs. These jurisdictions have certificate of needs for varying reasons. Some to control costs, like in the USA, to make sure that there is no overinvestment in facilities and over-servicing leading to high inflation in healthcare costs. And it's retained in 35 states in the United States, and that's documented in the affidavit. Even though there's criticism, there's a mixture of failure and success. The other countries, Denmark and the rest, are mentioned, and I can just give the court the references where the court will find this discussion. It will be in the answering affidavit from page 522, paragraphs 315, 316, and 527, paragraph 337, and page 529, paragraphs 350 to 355, and page 536, paragraph 378. So that's all discussed there. And in fact, the example the government gives is one of pharmacies, because like health establishments, the pharmacy industry is regulated, the establishment itself is regulated, and the pharmacy is regulated, pharmacists is regulated. In the same way with health professionals, you regulate the establishment, you regulate the practitioner. Because unlike a legal practitioner, nobody cares how my chambers look. But with a surgery, you want to know that you have the proper hygiene, you have the proper equipment, it's set up, it's safe, and all of those things. So those are regulated as well as the practitioner themselves. And so there is that evidence, and the counter to that is, well, if you're going to refuse certificates of need in particular areas which are over-concentrated, then you're not going to have investment in rural areas, because what these private hospitals want, and they say that bluntly, they want areas where people are employed and they are members of medical schemes and they can pay for their services. That's speaking for the for-profit. They're not speaking for the not-for-profit. They're speaking for the for-profit. But with great respect, nothing can be said in advance in this categoric fashion that if a party wants to establish a high-tech facility in an area that's already over-concentrated, may not consider downscaling, revising the investment, the facility, and providing a different facility at a scalable level with appropriate investments in a different area. The lawyers can't say that. No economists can tell you that, because that's a decision that hard-nosed business people will make. And they know that working with government gives them opportunities. So the opportunities for PPPs as well.
Mr. Manager, I think.
Yes.
You had the buzzer.
I had the buzzer, yes.
And I realized that your junior didn't have the time.
Yes.
She was promised.
Yes.
Yeah.
We could ask, I did ask that, because there is also an appeal, although our arguments are premised on defending the confirmation, that perhaps we could have a 5-minute where my learned friend can just deal with the justification and remedy, and in question time I'll deal with the rest of the issues.
So you're suggesting that your junior will address just the appeal, the issues in that?
Addressing justification and remedy, in the event that you find against us on the constitutional challenge.
I see.
Yes.
Okay. No.
Otherwise, in questions, I'll deal with the rights challenge if there are questions raised.
5 minutes it will be.
Thank you.
May it please the Court, Deputy Chief Justice, Justices. I think I'll commence with the test that the Court would have in terms of looking at the limitation in the event that the Court finds that the CON does limit rights. I would then, just borrow on the case that has been referred to by Solidarity of Manamela, where it says that there has to be a global judgment on proportionality, that as a general rule, the more serious the impact of the measure on the right, the more persuasive or compelling the justification must be. We submit that with, on the basis of what my learned colleague, Mr. Manager, had already said, that there actually is very minimal that's been limited. Because at the end of the day, whether or not a CON is it's granted or refused, the practitioner, the health practitioner, will still be able to practice and choose where to practice. And the submission that they would then be compelled to go to an area of not of their choosing, as was submitted earlier on, is simply not in the Act. The general complaint is that the CON cannot meet its stated purpose, which is the hope to equitable redistribution of the healthcare services, because it is then argued that investors will not invest on the fear of not realizing their investments, leaving everyone worse off. And then when we look at the jurisdictional factors in Section 36, the rights impacted, there's actually 2 rights impacted there, which is Section 22, that already in there is an inbuilt of regulation, which Section 22 provides that every citizen has the right to choose their trade. And then it has the second sentence that says, the practice of trade, occupation, or profession may be regulated by law. That in itself, it says that limitation is a constitutionally inbuilt limitation. It's not a limitation, it's a regulation. Regulation in itself is not unconstitutional. What we have to then test is what is sought to be regulated. Then it takes us to Section 27(1)(a) that deals with the right of everyone to have access to health and care services. The argument that came from the applicant, as my learned senior Mr. Manager had said, are more investor-centered, service provider-centered rights. But if one looks at the limitations in Section 36, the criteria that the DG has to follow in terms of 36.3 almost half of the criterion that he has to look at, or they have to look at, or rather take into account the interests of the applicant's clients, so to speak. The other rights that were submitted that had been impacted on sections 10, rights to dignity, 21, freedom of movement, residence, 25, the rights to property, those have really not been impacted, and simply because when you are practicing, nothing is taken from a practitioner. It's just simply the limitation of the establishment in which you may, and the ideal is to redistribute it to wider areas and not to over-concentrate it in the same area. And we refer the test for the jurisdictional factors in section 22 to Affordable Medicines Trust and others. This is the Minister of Health. Paragraph 70 just highlights what I would like to deal with now, that where the court stated that refers to the right to choose a trade. And then it says, it contemplates that the chosen profession would still be practiced, which is what would happen even if a con, or rather even if a con is imposed, and protects both the right to choose the profession and the right to practice a chosen profession. There's nothing in the con that limits that right. It therefore just only deals with how those healthcare providers who wish to establish healthcare establishment or engage in prescribed services as part of their practices may do so, and it regulates, as section 22 already foreshadows that regulation of a trade, and it only regulates the distribution. And there's nothing unfairly constitutionally limiting in seeking to redistribute for an ideal to have more access so that the majority of our people who are marginalized, poor, without any resources may be able to access these services. Deputy Chief Justice, if you may just indulge me on the issue of remedy. The remedy with our submission is simply that there's nothing in the severance of the entire scheme is not justifiable under the circumstances, because not the entire scheme is unconstitutional. The fact that it might lack, and this is not a concession, certain constitutional inbuilt does not mean, and even if does not mean that the entire scheme is unconstitutional. The submission in paragraph 129 of HASA that once you sever section 36, the entire scheme serves no purpose. It's equivalent to saying if you find one section in a single purpose legislation against of unconstitutionality, the entire statute is of no use. We submit that if the court does find, it would have to exercise its right in terms of section, or rather its discretion in section 1721B to the extent of the unconstitutionality. And because the Act has not come into account, rather into operation, the reasonable or justifiable or equitable thing to do for the court to suspend the operation of the declaration and refer only those aspects that the court find to be constitutionally problematic to Parliament. That would limit the scope of correcting what is wrong, if at all there's anything wrong in there. We've already dealt with the issue of costs. We will not ask for costs. We accept that it's an important constitutional issue. As the court pleases.
Thank you very much, Ms. Chabedi. So do we start asking questions to the senior?
Yes, and if there are questions for my learned friend also.
There will
But
be
I'm
questions.
happy to take the questions.
Let me start here, Mr. Manager. If we consider the doctrine of ripeness, I think it's part of your argument. You argued abstraction as well as prematurity. But let's look at ripeness. If we consider that persons affected by the Act may not at present be subjected to prejudice, but there may arguably be a real threat of prejudice as argued on behalf of the applicants and HASA, once the provisions come into operation, should we, in this court ignores such threat of prejudice just because there's no date set for when the provisions will become effective?
No, you shouldn't. And unlike in the High Court, we haven't argued that this court can't determine the constitutionality of the provisions merely because they haven't been brought into force. What we do submit is the applicants attract a higher burden when they challenge a statute in abstraction, which is still to be brought into force, because it's asking the court to look through the crystal glass to see what may happen in the future. So they must be able to show the court, persuade the court that just facially looking at the provisions, they are constitutionally invalid. And we submit that in doing that, they conflate two things. They conflate the mere existence of a power with what will happen when the power is actually exercised. Let's take an example with the renewal provisions and the provision to withdraw. So they say it gives the Director General the power to renew, and that's unconstitutional because it will produce prejudicial effects when that power is exercised and there is a refusal. But in fact, the prejudice will only arise when there is a refusal. So there might be a proper exercise of that power, and they would have no problem with the fact that there was a power of renewal. The only time when the issue arises, when they are truly aggrieved, is when the power is exercised and the certificate of need is either not renewed, or it is withdrawn, or there's a refusal for a certificate of need. And there are remedies for that, judicial remedies, and that's why the case they have to advance now requires them clearing a higher burden, because when the DG exercises the power and withdraws or non-renews or refuses, that is subject to challenge for legality, for lawfulness under PAGA, for procedural fairness under PAGA, and the court will rectify. The issue was raised that, but what would happen to the practitioner in the meantime? Now, courts grant interim remedies all the time. Even before the Constitution, the court will know of the judgment in Air Road Express of the previous appellate division, where a party applied for a review of a refusal to renew a license and sought pendente lite an interim license. And the SCA granted it because the court has powers to prevent hardship and to regulate its own process in dealing with the review. So there are remedies in the law which will prevent for situations where there's an unlawful refusal. But of course, if the court upholds the refusal or the non-renewal or the withdrawal, then it is lawful. It's consistent with the Constitution and it's consistent with our law. It's only in those instances where there is an arbitrariness. And also the suggestion was, but you can see the powers are so wide, they'll be arbitrarily exercised. Now, both in Van Rooyen, at paragraph 37, State v. Van Rooyen, and in, perhaps I can read the court what it said in Affordable Medicines at paragraph 36. It says the question whether there are any constraints on the exercise of discretionary powers is essentially a matter of construction of the empowering statute. In this regard, it is important to remember that subsection 22C1A, consistent with our jurisprudence, ought to be construed in a manner that is consistent with our Constitution, including the doctrine of vagueness if possible. And credit ought to be given to the Director General who has to administer this provision, that he or she will do so in accordance with the law and the Constitution. Were the Director General to issue a license on conditions in conflict with the powers conferred upon him or her, the decision could be set aside. The fundamental flaw in the applicant's attack on subsection 22C1A is that it does not take sufficient account of these matters, precisely the position here. So, both in Van Rooyen, the court said in Van Rooyen, where it was a challenge to the magistracy, the Magistrates Act and the regulations, that the mere fact that legislation is open to abuse, arbitrary decisions, is not a basis to invalidate the provision because there are remedies. The assumption is the functionary will exercise their powers in line with the Constitution and the law. So to poo-poo the DG saying it must be accepted that I will exercise the powers constitutionally and in accordance with the law is really not to take heed of what this court says in Affordable Medicines at paragraph 36.
Yeah. Let me just move, thank you for that. Let me just move to another point that you've really stressed within your written submissions. This test or approach that you say is in Savoy, to say those who advocate for interference on inchoate processes have a higher burden. That's what you say, isn't it? Now, you also argue in your written submissions in paragraph 92, but there you use the exceptional circumstances tag, where you say courts, I think you've cited a paragraph in the Law Society case that courts traditionally resist intrusions in internal procedures of other branches of government. Now, what I want to know is, the applicants have also cited authority of this court that says this court can do that. Now, what is it in these cases that you think should persuade us not to interfere?
Yes. Deputy Chief Justice, so I always have to distance ourselves from the arguments in the High Court. We are not persisting in the argument that this scheme is inchoate and the court cannot interfere.
Okay.
Except that once legislation is passed by Parliament, is assented to by the President and brought into, and is an act, this court can decide whether it's constitutionally valid.
Yeah, but that's my question, because I want to know why.
The issue
Yes.
So the issue we say is that where you're dealing with a challenge, an abstract challenge,
Yes.
which is that a party is not saying the legislation has been applied and in the application it has infringed my rights. It is saying that just looking at the legislation, it is unconstitutional, so we don't even have to wait for its application. That those cases merely say that the burden is higher because the circumstances in which that legislation is going to be applied in the future are so varied, we can't tell right now. And so we can't say with certainty that if this provision is applied, it's going to produce unconstitutional. Let me give you an example from the rights challenges, for instance. If you take the finding of the High Court which says that the section permitting for imposing conditions regarding triple P is an expropriation. And we know the court has said in Agri SA, expropriation must involve the taking away by the government. So the state must take away the right for its use. It doesn't have to be the full right, could be a substantial part of that right. So that judgment is rendered without engaging with how triple Ps are in fact implemented or may in fact be implemented. Now, in that context, the court must be persuaded that on any possible implementation of the triple P condition, there is going to be an expropriation. But I just indicated from the Regulation 16 of the Treasury regulations regulate triple Ps, and they're issued under the PFMA. And I refer to Section 45 of the National Health Act, which says triple Ps must comply with the PFMA. When you read the regulation, it's clear that when triple Ps are implemented, the private party stands to benefit commercially. So it's not an expropriation. But the court disregarded the actual implementation. The same with the Section 22 scenario. So they argue that Section 22 will discourage or will negatively affect the choice, not just the practice, the choice of profession. Because in their conception, the Act allows the DG to force a relocation and therefore undermine dignity and movement, freedom of movement. But Ms. Engelbrecht quite candidly said, the government assures everyone in their affidavit that there is not going to be a relocation. There's no power given to the DG to force people to relocate. All that the DG will say is you can't establish here, full stop. Not you can't establish here, go and establish there. So there is, that's in the application. And the same applies to the factors. When Justice Theron asked, but who is going to determine the need? The application should inform you. So there may be an invitation from government saying there's a need there for these reasons. An applicant files an application and says, I can meet that need in this way. That might be a constitutionally compliant implementation, but they want to challenge it today before its implementation. And the Savoy judgment and the others say, in that context, there must be a compelling reason, compelling case that on any circumstance, that legislation is going to be it's unconstitutional. And we've cited U.S. authority similarly, but is not directly on full square
Thank you, Mr. Manager.
legislation. Yes, Justice, Deputy Chief Justice, yes.
Thank you very much.
Thank you.
Thank you. Thank you, Mr. Manager. Am I correct then to assume that even in the absence of regulations, you're not bothered about that? You are here to defend the legislation? Or are you still saying because the regulations are not in place, they should not have come to us?
What we're saying is that because it is clear, and the National Health Act says the Act includes regulations, so it says that in the definition section. And the provisions make clear that they still to be detailed by the minister in the form of regulations to complete the scheme. On principle, on first principles, they're entitled to come to court and say this legislation, on the face of it, is unconstitutional. What we are saying is, in the absence of regulations completing the scheme, they face a higher burden to convince this court that this scheme, just on its face, is unconstitutional. But we're not trying to argue that the court can't even enter the inquiry about the statutory scheme just because the regulations are not yet in place. But it does make their case far more difficult. And I take the example of 36(1)(c). The court doesn't know which health services will be prescribed. There might be what is generally called, what do they call them in medical scheme, in the regulations, minimum prescribed benefits. Those are essential services where even medical schemes are required to fund them, And so you might have a regulation that prescribes only what is already prescribed minimum benefits. Everybody knows what they are. The health industry knows very well, medical schemes know what they are. So there might be no vagueness. But because they are coming today before the list of prescribed health benefits, we submit they bear a higher burden to show that that provision is so vague, it can never be constitutionally compliant. That can't be correct.
You said that the DG will not say to an establishment they must go and operate in that particular area. All that the DG will say, they would probably not grant the application. If that is the case, what happens to the establishment if the CON is not granted?
So there would be differences between a pre-existing establishment and an establishment which is applying for the first time. If it is applying for the first time, there may be various options, considering other areas to apply to, or adapting their investment, the scale of what they wanted to build, and so on. So there are various options. An existing facility, which is not given a certificate of need, of course will be like any party whose license is not renewed, would either have to challenge that as being an unlawful refusal, if it is unlawful. If it is not unlawful, that is lawfully refused. And
which would mean that if it's not approved,
yes,
and it's challenged, and the establishment does not succeed, it would not be able to operate.
Yes, that's the nature of regulated industries. You go in, at risk. In fact, this is not new to this. With mental health institutions, they also have to register under the prevention, there is an act, but I just don't remember the name now. But they also have to register, and they register for a duration. The registration must be renewed. It's for a limited period. If that registration is not renewed, the mental health institution has to find an accommodation for the patients with another mental health institution. And it happened, there was a reported case of Akiso, which didn't have, was given a temporary license and wasn't renewed, and there were issues. So that happens ordinarily in all regulated industries. It's the same when in general commerce, if you are a party that wants to merge with another party, you have a right to do so, but you seek permission. If it's not given, you don't proceed, despite that there was a business opportunity. That is the risk inherent in operating in regulated industries. And health is a highly regulated industry for a good reason, because there's a great risk of life and health, in health. So safety is important. It's unlike law. The question that, are you now saying certain professions are less regulated than others? Yes, it is true. That is the case. I'm sure firefighters are differently regulated. There is greater risk there than...
No, the concern is you're talking about an establishment that has been there for years.
Yes.
And then all of a sudden, the certificate is not approved. And then it is expected to just close shop, because if it's not approved, it cannot go to the other location. That's a concern that is raised by the applicants. And there's a loss of investment and employment opportunities as well.
Yes, there are adverse impacts. We can't run away from that. But even as we speak, Section 82, capital A, 1D of this Act provides for closure on non-compliance with conditions for registration. So that you may have closure of a health facility is an inherent risk. But we're working on suppositions that there will be refusals, and those refusals will require immediate closure, that there will not be a transition period to allow for the relocation of patients and the like, and considerations of how one deals with the investment. All of these will be regulated in the regulations. So one can't, speaking today, assume that it will be, in the case of mental institutions, they're given a period of time in which if you don't get a license renewed and you have to close, you're given a period of time for relocation and the likes. But yes, the risk of losing an investment is always there. Even me as a practitioner, if I'm removed from the role, I lose, my children may stop going to school. But that's the reality of operating in an industry that's regulated in the public interest.
Is there any provision in section 3, that is 3, yes, sub 36.3, that would cater maybe for incentives or subsidies, something like that?
I beg, subsidies?
Subsidies or incentives under section 36.3.
I'm not certain whether the Act envisages the public sector subsidizing the private sector. It may come in different ways. There may be tax concessions of some kind. That's not an issue raised here of subsidization, so it's not dealt with on the papers. But we know that even with medical schemes, there's some tax benefit that users of medical schemes gain from getting. So I'm not certain that is envisaged here, but certainly, if a PPP is regarded as a form of government assistance to the private sector, that may be so, in that there is a business opportunity given to a private sector party to run a public institution for commercial benefit. The only thing is that the private party will take the risk of operating because it gains. There's no gain without risk. But that's a benefit that immediately is apparent from the possible condition of a triple P.
Thank you. Thank you, Mr. Chair.
And that condition, it's important to always remember, under affordable medicines from 35 to 39, is not a carte blanche for the DG to choose what condition he wants. The condition is constrained by the purposes of the National Health Act and the CON provisions and the requirements that he must put to bear when he considers an application. So he can't just say, and remember, in part one of the requirements under 36(3)J is to consider the financial sustainability of the health establishment or health agency. So when he imposes a condition, or she imposes a condition, it must be a condition which will not leave the health establishment unsustainable financially. So there are all those constraints built into Section 36. It's not carte blanche as it's suggested. There is this broad, unconstrained power.
Mr. Manager, just on that very issue, am I correct to say that it's the DG or the minister who actually determine the need? And they are the ones who will actually determine whether there's a need or not, and then whether to give that certificate or not?
Indeed, the need, and there's a good reason for that. In fact, one of the criticisms made is that the department has no database. And I just want to look at a volume which contains a policy. So you will find in volume 7 at page 555 that there is a policy, a master health facility list policy, 2023, which is in draft form. That policy will assist the department to create a database of the facilities available in the country. Other countries have these kinds of databases, we don't have. And from that database, and knowing the special distribution of our population, the department will, let's take the Baragwanath case, for instance, and I can't testify from the bar, but if there are initiatives in respect of Baragwanath to decongest the facility, it's the biggest hospital in the country, but it's serving a huge population, not just South Africans, but also our neighboring countries. And so it's undercapacitated for the numbers that it has to serve. So there is a need to decongest it. So the department might identify a need in surrounding areas to establish clinics or outpatient facilities or small hospitals with limited number of beds facility. And when having identified that, there might be an invitation for interested parties, private parties, to apply, either on condition that you go into PPP or simply that you're applying, you're going to run the facility. And so the application will be made, you would motivate. Like in applications for licenses, ICASA does that all the time. They issue an invitation to apply. And you apply and you satisfy the department that you can meet that need.
Okay, thank you. And if you are a healthcare provider, you are a health establishment, and you apply for the certificate of need, you need to know exactly what the criterion is and what your prospects are. And when I look at Section 36(3), those factors are couched in broad terms. And personally, maybe because I'm not in that field, I struggle to understand what exactly is meant by these broad categories. And maybe the minister and the DG know, but then I'm putting this question from the perspective of the healthcare provider. Will they be able to know? And maybe I must ask you the second question. Why is there such a delay in regulations? I'm asking this, Mr. Manager, because when I look at the date of commencement then, it was 2 May 2005. And there's been amendments and all of that, and it's not clear to me when these regulations will come into effect. And I'm just worried that if the regulations come, they only have 24 months to comply. And I'm worried that whether that 24 months is actually adequate, I don't know how many healthcare providers want to make use of this. And I'm worried that if it has taken about 20 years for this to take effect, whether it's going to take more time and whether there'll be adequate time comply? Because as I see it now, it's not very clear, it's in broad terms.
Yes. Yes. If I can take just each one of those questions. So the legislature would legislate in this way by providing considerations which are broadly stated. They leave the detail to the minister to flesh them out, to say, for instance, we require this kind of information to be supplied with your application. That's things that the minister would be able to prescribe under Section 31, because that Section 39(1) says the minister, after consultation with the National Health Council, and I just want to pause there. The court will go back to the definition of National Health Council, and you'll see that it is established in terms of Section 22 of the National Health Act. And it includes representatives of provinces, local municipalities, and the like. So the minister will consult representatives of provincial and local government in making regulations under 39(1), which will deal with A, the requirements for the issuing or renewal of a certificate of need, the requirements for a certificate of need for health establishment and health agencies existing at the time of commencement of this Act, the requirements for a certificate of need for health establishments and health agencies coming into being after the commencement of this Act, and any other matter relating to the granting of a certificate of need and the inspection and administration of health establishments and health agencies. So those will be, the broad nature of the considerations will be filled up in the detail that will be provided in regulations. So that's the first answer to that. But you can expect the legislature to regulate in broad terms, because like Justice Chitli, you raised, as much as the court is not familiar with the landscape for health industry, so is Parliament not fully familiar with the landscape. But the practitioners, the people involved in the industry, know exactly what you require. So, and these regulations will be published for public comment, so the members of HASA and health practitioners will comment, this is unclear, we don't know what we must submit, that is unclear, that's, and so on. So that's how the flesh, as it were, will be put on the broad categories. But legislature will regulate in broad terms and leave the details to the executive. That's the best way of administering. Our courts have acknowledged that in AAA, the judgment of this court in AAA, dealing with the micro financing, I think, if memory serves well, it recognized precisely that delegating down to the executive to fill up the details is indeed the function of the executive. And also in Mpumalanga Petitions Bill, which was my first case to appear in the Constitutional Court as a junior, there too was legislation to be administered by the Speaker of Parliament, which left the detail about a petitions process for the public to petition the legislature, the details to be filled up by the Speaker. And this court said that is appropriate because the Speaker is on the cold phase of implementation and would know what is required, like in the case of the executive. So that's
I accept that, Mr. Manager. I thought that when you were submitting, you said that it's easy to make out what is required. I thought that was your submission, that it is easy to make out what is required if one reads the text.
Yes.
Yeah. I thought that was your submission.
Yes, it is still my submission, Justice Chitli, that one can make out what these factors require. When you talk about equitable distribution of health services, there was an issue about what is equitable. In these papers, you'll find lots and lots of articles published which say we don't have an equitable distribution of health services. That's acknowledged by industry participants, is acknowledged by the government. So everybody knows what is taking place here. When you say financial sustainability of the health establishment, the applicant knows what income they need, what turnover they need from, if they are for profit, what turnover they need to run a a health establishment profitably. They tell you how much it will cost them to establish. They would know what the operating expenses will be, and so they can know how to budget for these things. They have actuaries.
Would they be able to make a judgment call on the need to promote an equitable distribution and rationalization of health services and healthcare resources?
Yes, they will. They've already been in the submissions here. They told you about machines that they invest in, and you need a highly populated area for high capital-intensive machines that must be used for the population. So they are not. It's not the council team that engages in this thing, and it's not us as lawyers. It is economists, financiers, actuaries who can project all of these things and work out models, financial models, and model whether a facility in the middle of Soweto for 200 beds with whether that will be profitable. They can model all these things. They are very sophisticated, Justice Chitli. They know what these things mean. That's why in the High Court they said they have no difficulty to understand what is here, but the problem is what is not included here. So they know what is included. They've never said they don't know.
So they have a problem with what is not included.
Yes.
And you say that even if what is not included is not here, there is no problem.
I've said firstly that what they complain is not here, is a matter of interpretation. If you interpret the requirements properly, you will see that what they complain is not here is in fact here. So firstly, they say there is no factor dealing with over-concentration of facilities. The only thing you have is C. It's B, the need to promote an equitable distribution and rationalization of health services and healthcare resources, and the need to correct inequities based on racial, gender, economic, and geographical factors. Now, let's take geography. They know the areas that are over-concentrated, and they know the areas that are under-serviced. That means there is no equitable distribution. So when you're asking about equitable distribution, you can't answer the question without considering concentration levels. So it's not true that it's not there. It's a matter of interpretation. The High Court did not grapple with interpretation. The High Court almost lapped up everything that the applicant said, and that's the judgment. That's why even triple P is an expropriation in the paragraphs that the judgment concluded. And then they say there is nothing here that relates to the interests of the applicants. And I've shown the court that paragraphs G to M look at the requirements from the perspective of the applicant. Financial sustainability, the applicant knows what the financial models will illustrate about a potential facility in the middle of a village. So in any event, we make a second submission on that, is that even if it was completely silent about the interests of the applicants, this legislation, this section, must be read subject to Section 33 of the Constitution and PAGA. And Joseph says, when you're making decisions that may adversely affect the interest and legitimate expectations of other parties, you must comply with PAGA, not review. When you're engaging in the decision making, you must comply with PAGA. PAGA in Section 3 and Section 4 requires that you must follow a fair process. And a fair process means they're given an opportunity to make representations. So when they've said it's not going to be financially sustainable, and the department disagrees, they must be invited. If that is going to be determinative of the decision, they will be entitled to make representations on why they are right. And the department must listen and engage with those representations. That's what a fair process requires. And legality requires that it must also follow a rational process. So, and rationality sometimes requires that you must hear a specialist in the field. They are the specialists. When they say there is a need there and you debate the need with them, you must hear them. And otherwise the decision is not procedurally rational.
Thank you, Mr. Manager.
Thank you.
Any submissions on the regulation?
Oh, delay, yes, let me deal with that. So it's correct that there has been delay, but there is a reason for that. The regulations from page 77 were published on 15 June 2021. They are drafts, so they must be public. Let me see. If this is probably for public comment. This was for public comment. The minister, after consultation, intends to make the regulations, so there's comments. Immediately these regulations were published, this application was launched by Solidarity in December 2021. So you'll see that in volume 1, that the application was launched in December 2021. And obviously there are delays in the administration of justice for reasons we all know. And the department, out of respect for section 165 of the Constitution, which requires all organs of state to support and protect the judiciary, that obligation did not go ahead and waited for the outcome of this application. That's what has held up the regulations. So this court, if this court were to accept my learned friend, Ms. Chavedi's submission that as part of the just and equitable remedy, the court can consider a suspension remedy to allow the minister to carry on with the regulation-making process, because if the sections are struck out, that regulation-making process can't continue. And so when even if Parliament fixes, and in 24 months' time you have a new act, without regulations, we'll probably be before the court again. So you do need that at a time when the Parliament fixes whatever defects the court identifies, that regulations have been made pace. Because as we submit, not everything in this section 36(3) even is objectionable, is what is not there. So there's no reason why the remainder cannot be addressed by regulation. There's no challenge to, there can't be challenges to others of the sections. I started with the sections I submitted were not constitutionally objectionable. So that's the explanation in relation to the draft regulations, Justice Chitwe and the court.
Thank you.
Thank you, Mr. Manager. I just want to deal with the question of the abstract challenge and link it to the question of the rights limitation, on which we had the benefit of quite limited argument because of time constraints.
Yes.
So it seems to me one of the problems that bedevil us today is that we don't know how this will play itself out once the regulations are in place, and how the system will work. But when I think about it, I can imagine, for example, to the extent that there has to be an equitable distribution of resources, one would expect the Department of Health to do an overview with regard to needs versus population density and indicate areas that may well be overserved and areas that are underserved. And those would be a matter of public knowledge, for example, because that's what you need to have, even leaving the act aside, to transform your healthcare system. And I'm not sure how the system of applications will work, for example. Which brings me to the question of limitation. Firstly, it would seem to me that Section 36 does constitute a limitation. Because
Section 36.
Yes. Of various rights, because this court has distinguished between the regulation of a right and when the regulation of the regulation for the exercise of a right breaches the boundaries of the right and constitutes a limitation. It would certainly seem to me that this would constitute a limitation. And from Ms. Javedi's argument, it would also seem she went into the justification analysis. I don't want to suggest that she conceded it's a limitation, but my view is certainly that this constitutes a limitation, which takes us to justification. And I'm not sure how it's going to work, and I was thinking of an example. So let's assume that the young person from Parktown that we heard about this morning is out of medical school and wishes to apply for a certificate of need. applies to have a certificate of need issued in respect of Parktown. The department refuses it, but says in the refusal, by the way, on our list of areas in need, we may favorably consider the issue of a certificate of need in Midrand. And the very next applicant is also from Parktown, but gets a letter from the department saying, we refuse it. And the nearest area where we could accommodate you where a certificate of need may be favorably considered being Toyando. Now, in those two scenarios, accepting that there's a limitation, whether the limitation is reasonable and justifiable will depend on the particular facts in those cases. One may say in the first case, asking him to reapply possibly and to suggest to him that he could get a certificate in Midrand under circumstances where he has not commenced practice and not invested any money may well be reasonable and justifiable in an open and democratic society. But in the case of Toyando, it may well not meet the limitations test. So the difficulty I'm grappling with, and my question to you is whether one could, here and now, say that the scheme will in all instances result in a limitation of a right that could not meet the Section 36 test. Because one of the factors in Section 36 is the nature and extent of the limitation. So the nature and extent of the limitation may be much more egregious if a person is forced, in brackets, to have to apply for a position in a certificate of need in Toyando as opposed to Parktown. But the difficulty is that one doesn't know how this is going to play itself out, and what I'm speculating about may not come to pass.
Yes. Can I just answer that in three parts? The first is to say the focus on individuals really comes under 36(1)(c), because that's the one that you want to provide prescribed health services, you must get a certificate of need. But that, we don't know the list yet. And until you know the list, you can't determine that there is a limitation already. That's the first. The second point is in relation to establishments and in relation to individuals who work for establishments, they will not need a certificate of need themselves where the establishment has a certificate of need. And that's made clear in the answering affidavit. So against that backdrop, I must say that there is no concession that there is a limitation. Firstly, in relation to human dignity is about restricting movement. There is no power to the director to direct where you shall go. The second, and that applies also to Section 21, which is the freedom of movement. So those run together. In relation to Section 22, as Justice Colapan pointed out, you are dealing with a qualified person wanting to practice their profession. So it's not about choice and entry into the profession. It is where and how they can practice their profession. So it's a regulatory, it falls under the part on regulating the practice of a profession. It doesn't prevent, nor we submit, it doesn't negatively lead to people not choosing the profession, because when there is an admission requirement, on its own is not that determines how you will practice. Well, admission requirement is about entry. That's a bad example, but if at the bar we have a practice requirement that you must practice in approved chambers, for instance, that's an example. So that relates to your practice. To negatively affect choice, looking at the requirement, it must discourage you from even choosing to pursue that profession. But that's not the evidence here. The real evidence here is that it affects how you practice, and so it's a measure which must be rational under Section 22. And we've said the provisions are rational. I've argued that. I'm not going to repeat the argument. And in relation to property, there's no deprivation of property when a CON certificate is refused. No substantial interference with property ownership rights. In expropriation, there's nothing taken away. There is no right taken away or substantial right. And 27, there is no prevention of the public from purchasing private healthcare services. The intention is to expand reach of those healthcare services. So we submit, our primary submission is that there is no limitation. And the submission is consistent with the written argument, and we stand by that. But as for the limitation, I accept the court's, the question asked by Justice Colopin that justification is context specific. So it's much easier to evaluate justification where there are lived cases. Somebody has been refused. But the difficulty with justifying also accounts for why it is unfair to expect that the department in its answer could have produced facts and evidence to support justification, because all of this is argued in the abstract, something still to happen. And that difficulty also highlights why the burden to establish an abstract challenge of this kind is so much higher, because the department is deprived of the ability to justify, because it is difficult to determine, in the case of the individual example, what would be the extent. If that individual finds a job with another health establishment, they may not need a certificate of need, or as an individual. So it's contingent on circumstances that we can't foretell where we are.
Thank you. I do have a different view with regard to the limitation, because we
do submit that despite that difficulty, we can show that the interference is minimal with the rights, because we are not taking away your rights of ownership, we are not directing you to move to particular areas and so on.
Well, I'm saying it may be context specific. There may be cases where it might be clearly a case of an unjustified limitation, which is the Toyando case, for example. But let me get to my last question.
Could I just,
sure.
Just before Justice Colopin follows up, so just to make sure that the last bit of my answer was taken, not accepted, taken, in the sense that I did come across that our submission is when one assesses the scheme and the complaints about how it interferes with rights, if there's any interference, is a minimal interference, because it doesn't achieve the outcomes which they say it does, of forcing people to change their homes, to leave their families and the like, or to indeed to take property away from them. And it is important also to acknowledge that it's a reality of life that you don't always work where you choose to live. You work where the work is available.
Okay, I just want to make sure that's your submission. I'm saying that there could be instances where the interference is minimal, and it doesn't reach the level of, or rather the justification argument is sustainable, and there could be cases where an argument of justification may not be sustainable. Yes. That is best assessed on the facts of those
I accept
cases.
that proposition, Justice Colopin, just to be clear. I accept that if this challenge came when the regulations were in place and the CON was being implemented, we could have a situation like that. I accept that.
My last question is in response to Justice Ntlantla's question with regard to the closure of an establishment that does not obtain a certificate of need. You referred to Section 82.
Yes, I said...
But Section 82 is closure under circumstances where there's some form of culpability, not so?
I accept.
Sure. And here we would not be dealing, and so therefore one might say that under those circumstances, closure meets the legal threshold because there's conduct that is culpable and therefore the consequence is closure. But here we're dealing with an establishment that may not have been culpable, that may have been fully compliant at all times. And it would face closure under circumstances where there may not be any claim to compensation. Is that not at odds with the sort of architecture and the spirit and the values of the Constitution?
I accept the distinction between where there's culpability and where there's no culpability. Our primary submission is that non-culpable closures resulting from non-renewal or withdrawal of permissions is found across many legislation. But of course, that is not responsive to the particular question here. But the point here is, in advance of an application for a certificate of need, we are supposing that there will be a refusal and the only option will be closure. But it's unclear what the regulations, what regime the regulations will put in place, whether it will put in place transitional measures and the like, which might ameliorate the position of the owner of the establishment, which would go some way to minimizing the impact on that owner. We don't, those things are still to be threshed out in regulations.
Yeah, sure. I mean, that's quite widely speculative. I mean, you could say, well, if you don't get a certificate of need, then you can apply for a casino license. I think we're talking about the reality of closure, not so.
Yes, yes. So we are taking the worst case scenario and testing the proposition. Our first submission is, so the government and the department is entitled to change the regulatory framework, and South African Diamond organizers that legislation acknowledges that a change in the licensing regime is not a deprivation of a right or expropriation. There's a right to change the licensing regime. Assuming the licensing regime is itself consistent with the Constitution, the implementation of it in a lawful manner which results in a closure would not offend the Constitution. And it will be a risk of doing business in the regulated industry.
Minded to adjourn for 15 minutes, right? It's been 2 hours since after the lunch.
Yes.
And so I'm going to request colleagues that we adjourn for 15 minutes and then come back and continue.
As the court pleases.
You hold back regulations and then you say, well, now there are no regulations, so you have a higher burden.
Frankly, we are not asking the court to refrain from determining the constitutionality of the own provisions on the basis that the regulations are absent. All we are asking is the court to take into account what that means for the court to be persuaded that these provisions are on their face.
I ask you about the Affordable Medicines Trust case which you rely on. Will you accept that this, although it's called a certificate, it looks more like a license? There's an application, there's a renewal, there's conditions, there are penalties. Will you accept that just on that basis it looks more like a license?
I will not dispute that.
It's not like a certificate of competence or aptitude or something like that.
I'll accept that there's similarities between this scheme and a license.
Yeah, let's leave it there. But now, Affordable Medicines Trust was a case about licensing, and was about licensing in respect of dispensing medicines at specific premises, not a bar to where you may dispense. Do you accept that on that basis, the two cases, that case and this case, they are fundamentally different? Just on norms and standards, did I understand you correctly to say that these certificate of need provisions, these impugned provisions, also have in mind setting norms and standards? Is that your submission? For establishments, new establishments, and establishments who are already in existence 2 years after they must apply? Because I find that strange that when you have an entire chapter 10 devoted to norms and standards in the NHI, including an Office of Compliance with Standards and detailed provisions on it, and then in addition, that's for the establishments, and then a number of statutes which deals with health professionals like the dental profession, medical profession, the pharmacists, and so on, that you need this legislation to cover that as well. It seems to me that there's only one objective. There isn't a primary objective and a secondary objective. It must only be the primary objective which we must decide in this case, isn't it? With that in mind.
Oh, sorry, I've not been recording. I didn't press this for the mic. I hope that I was still audible.
You were audible. You weren't recorded. But Mr. Mr. Maneche, I want to ask you about the regulations. Do you accept as a matter of principle in law, regulations, if these provisions are found to be unconstitutional, one or more respects as alleged, whatever the regulations can be, they can't rescue them. They can't rescue them from unconstitutionality. I mean, it's not even hoisting yourself up by your own bootstraps. It's using some other bootstraps to try and hoist yourself up. You accept that that can't be?
Yes, I can't use those bootstraps. I can only use them for interpretive purposes, only in limited circumstances where, for instance, we're dealing with prescribed health services. I can say those are envisaged to be prescribed in regulations. When one assesses whether that provision is vague, one must take that into account. That is not simply saying health services without saying how they would be described, and that is permissible.
When I say nothing, I don't necessarily accept your submission, but let me move on.
I know, Justice Majid. You accept, you're saying you've heard my submission.
Yeah, I've heard you. Now, that brings me to the last question, which is this prescribed health services point. If you go to section 36(1), and this is the point that all the applicants as counsel, both counsel have made for the applicants, and that is there's this just disjunctive or after C. Now we know that that means that prescribed health services then can't be used in respect of any of A, B, or D, isn't it?
Yes, that's the self.
So can you explain to me this prescribed health services argument in the light of that disjunctive or at the end of C? What is your submission there? I didn't quite follow it.
So I accept that the use of or between C and D suggests that A, B, C, D are all disjunctive. And in a sense, they are self-standing self-standing circumstances under which a certificate of need would be required. And our submission is A, B, and D are directed more at the establishment, so the private establishment operators, and we accept that C would hit more the health providers, and that will have a limited reach because it depends on the prescribed health services. So it's not, one must read it to mean it is not all of the health services as defined, because if that was the case, there would be no need to add prescribed. But prescribed meaning there will be a class that the minister will list in a regulation.
That was my last question, but can I just say this? I understand government's predicament in the sense that this section 27 imposes constitutional obligations. And there's a disparity which also hails from apartheid spatial planning that must be addressed. And if we find that, I say if, we find that these impugned provisions are unconstitutional from one or more of the grounds advanced, then they infringe rights, sorry, not unconstitutional, they infringe rights. Then we must do an analysis in terms of section 36. Now, one of the things we must ask is whether there are other less intrusive means available to government. Now, why does government not say to private health establishments, we will give you tax incentives on your construction and or on your other capital expenditure or on your other current expenditure like salaries and so on? Why doesn't it say to health professionals, we will give you tax breaks, or we'll give you a tax vacation for 3 years or 5 years or 1 year? I mean, surely these are means that must be considered. It almost seems to me like the proverbial smashing of a mosquito with a sledgehammer. This what is happening here, and I say on the face of it. Persuade me otherwise, please, Mr. Manit.
Well, so it is fair to put the proposition that there may be various measures which may be more optimum out there to achieve the purpose. and maybe one of them is the suggestion of tax breaks. But if one reads the HASA affidavits, you'll see that that too would not be an incentive enough. What they are saying to the court is they want populations that are employed, that are on medical schemes, that can pay these facilities. So there is no panacea, it's in the affidavits, there's no panacea with respect. And the DG acknowledges as much that we have a complex health problem. There is not one intervention that will solve it all. So even that, the tax breaks might have to be implemented in conjunction with the certificate of need to incentivize the health establishments to establish in rural areas. But it's not included here. And I'm not a policy planner, and the court is not the executive, so we assess what the executive has chosen. Except that in the limitation analysis, we are required to ask the question. But perhaps the only submission I can make is there is no obvious solution. My learned friends were also asked, what would be the less restrictive measure than the certificate of need? They all say, well, if I'm not recollecting correctly, they'll certainly correct me in reply. They can't come up with any ready answer. The affidavits don't come up with a ready answer. The articles you see in the affidavits don't come up with a ready answer. The articles refer to jurisdictions which have adopted certificates of needs as measures that might work. Works in others, don't work in others. So there is no foolproof. And I think it would be unfortunate to say, well, the government just latched on this. It is clear that if you look at the white papers and the various reports, there has this issue about access and distributing access equitably has engaged governments and industry players for over a long period of time. If there were easy answers, we probably wouldn't be here. But there are no easy answers, and government has adopted this scheme, and they say the scheme is unconstitutional, and the test for the court is, does it offend the Constitution? And if the court finds that, that's what the court finds.
Thank you, DCJ. Mr. Maneche, Justice Majid already touched on this aspect. At paragraph 114 of your submissions, you say that the CON aims to ensure that the health establishments comply with the same minimum standards. Is that indeed what Section 36 wants to achieve, and how would it achieve that?
So I said it's incidental to the main purpose because if you look at those criteria, they look into your facilities, they look into your HR, human resource allocation. So they assess the establishment that you propose to establish. And so there is an evaluation at a level of quality that you would be able to provide that service. And it has also said, also one of the requirements is whether you will be able to provide the quality health service. And the reason is the preamble makes it clear that the purpose, and Section 2, is to provide equitable health care services, so best possible healthcare service on an equitable basis. So there is also a focus on quality of the service that is provided. So even though it's not the main focus, in the evaluation of the application, there would be an inquiry about, are you able to maintain quality, and that calls for standards.
And the first to the 7 respondents point out that there are already regulations in place dealing with norms and standards of different categories of health establishments. Is that so?
That is correct, but of course it doesn't mean that that is the exclusive way in which quality is measured. So there may be other interventions which either overlap or cross-refer or adopts those standards, but the measure of assessing whether a health facility meets the Section 36(3) requirements would also call into question ability to meet quality, provide quality service to the community,
as well as
given its disease profile.
As well as Chapter 10. So you have the regulations, Chapter 10,
and Section 36 dealing with basically the same thing.
So what my submission is, I don't dispute that the main provisions in the Act dealing with health norms and standards is in Chapter 10.
Yes.
That is not to suggest that that is the exclusive domain for when the department is entitled to assess for quality. The quality may be assessed in other contexts, for example, when they are assessing whether a CON certificate should be granted. That's the full extent of my submission. I'm not suggesting that the CON is providing a new regime for norms and standards over and above the regime in Section 10.
Thank you, Mr. Manager. Thank you, DCJ.
Mr. Manager, clearly Parliament is delegating certain powers to the Director General and the Minister of Health. How would we classify those powers or identify the power that's being delegated?
We submit that it's subordinate or regulatory making powers, it's not plenary. The Minister and the DG are not given powers to change anything in the legislation. It's to fill up the detail.
But those, whatever powers are delegated to them, should be clearly identified. They shouldn't be open-ended, you would agree?
Yes, and our submission is they are clearly identified.
I have some difficulty with some of the criteria that's set out in Section 35, sub 5 and 6. Says the Director General may issue or renew a certificate of need having subject to compliance, and then may impose any condition regarding the nature, type or quantum of services to be provided. Number 2, human resources. 3, public-private partnerships. Training. Isn't that too broad, all those criteria and conditions that may be imposed?
They may be broadly stated, but they are criteria that are constrained by the purpose of the legislation and what the certificate of need is intended to achieve. So if they are going to advance equitable access, they are in line with the provision.
But where we're dealing with delegated power, Mr. Manager, mustn't that power be circumscribed?
It should, but one must bear in mind what affordable medicine says. You must read it in line with the purposes of the legislation. So it's not a wide-ranging power, and also you must bear in mind that it is constrained by the Constitution. You can't breach rights, for instance. So you can't impose a PPP without the agreement of the private party, because, as I indicated in Section 45 of the very same Act, it requires that a PPE be agreed and be in line with the PFMA, and that is regulated under the PFMA.
But if the if the Director General may impose any condition regarding the nature of the services, isn't that too broad? Not talking about whether the conditions would be contrary to the Constitution. Isn't that alone too broad when we're looking at delegated power?
Respectfully not, because the department could identify a need for a particular service. Say, in an area served by a general hospital, it might identify that you need a renal facility, or you need radiology facility, or you need some other form of specialist facility, and can identify that as a need for that area. So when you apply for a service, you apply for that. In fact, hospitals are classified according to the services they provide. So you may have a specialist, you may have a mental hospital which does only that, and you might have an outpatient health facility which only sees patients. They don't sleep out, they leave, and it's limited as to the number of hours people can be in that hospital. So there are already inherent limitations in what type of health services a particular facility can provide. And in this case, it would really be the nature would be also limited by the kind of need that is identified already in the section 36(3)(d). You can see that you can take into account the demographics and the epidemiological characteristics of the population to be served. That's the disease profile of that population. So there might be a particular need for a prevalent condition which is untreated because of lack of access in a particular community. There's nothing wrong in indicating a nature, but it must also be understood that often this application processes might be iterative between the Director General and the applicant. So the Director General might say, only if you can include this service, and the applicant might say, we can't, we don't have the budget for it, and so we can only provide particular services which may become the condition. So it mustn't be looked at that these conditions will be imposed like guillotines without engaging with the applicants, because that's what PAGA requires. There must be an opportunity to hear the applicants. And in that context, all of these questions that look on face value to be too broad may be really understood.
It's my last question, Mr. Maneche. If we look at 36(3), which refers to the quality of health services rendered by the applicant in the past, and we look at 36(6), which talks about norms and standards, and whether the establishment constitutes a risk to public health, are those not areas regulated by the Medical Council of South Africa?
I'm not certain which, is that the Medical Council, with that, not the Health Professions Council?
Yes, whether it's specific, industry specific, or related to a particular practice, area of practice, but aren't there councils that regulate that?
The Health Professions Council regulates the conduct of practitioners, but that's their ethical and professional conduct. So for instance, you go in and say, I've got a problem with my finger, and they operate your back. That's over-servicing, and that might be an unprofessional conduct. Or they might be an optometrist who says, I can give you an advance on your medical aid to buy spectacles, sunglasses. That might be unprofessional conduct. That's what the Health Professions Council regulates, is professional standards like the LPC. But as to the way in which you practice, whether you can establish a health facility, that's a department role, is not. The Health Professions Council also falls within the department.
36(3) refers to the quality of health services rendered.
Yes.
Wouldn't that be a matter falling under jurisdiction of the councils?
No, it's not a conduct issue, it's a quality issue. It's the patient's experience of the hospital. You go into a hospital and you are treated, are you treated well? Not improperly. Improperly would be the Health Professions Council, because now you are breaching ethical obligations. Here is, are you treated, are you given quality service? I can't think of
I don't mean to debate the point, but if the services that are offered or given is negligent or below standard, then that would fall into the perimeter of quality.
It might straddle both. It might be an ethical issue, professional issue, but it may also be a quality issue. Justice Toron, I know that you were in the bench dealing with, and was part of the court dealing with the Mediclinic case. In Mediclinic, you'll see it's discussed that at the time when the judgment was, when the matter was handled in the tribunal and in the Competition Appeal Court and before this court, there was no standard in the industry to measure quality. Quality is completely different from improper conduct. And what the department is doing is to, by norms and standards, is to plug that gap to measure quality. So quality where it doesn't become unprofessional. It is simply that your experience, your patient experience is not good enough. You were not treated properly. Not that you were treated improperly, it's just,
but if
I struggle to give an example, Justice Toron, but
if
I
a
accept
patient
the
has a
overlaps.
complaint, If a patient has a complaint regarding the quality of the service they receive, surely that complaint should go to the respective or particular council of that profession.
Yes, but let's take the legal profession and the health professions council, the LPC and the HPCSA. So you could come to one lawyer who gives you legal service, but is not so shoddy as to be unprofessional. You can't complain to the LPC and say, I went to that guy, he's a poor lawyer. That's not unprofessional conduct. But that relates to quality. So in the same vein, when you go to a doctor, he treats you as a doctor should, examines you, takes your history, does everything, and gives you a prescription. But you go to the next doctor and he treats you better, as in your experience and your response to the treatment is quicker, and you think, that was better quality, this is poor quality. You may still not have crossed the line for unprofessional conduct, because you're complaining...
I'm not sure I follow you completely, but I think you've taken it as far as you could.
Perhaps that's right.
Thank you very much. Thank you, dear.
There's a court, please.
Chief Justice.
Just before you sit down, I think I need to point out that your submissions ran to some 121 pages.
They were reduced by the direction of the court. And we were asked to reduce the submissions and file 60-page submissions on the 4th of September, which we did.
Yeah, 60, okay.
60 pages, yes. We submitted 59 pages, but with a separate list of authorities. But we did comply with that direction.
Okay, no problem. Thank you very much.
And we do apologize for the 124. There was too generous in the way in which the case was argued, and we could tighten it, and we did when the court said we must do so.
Okay, thank you.
As a court, please. So is that my learned friend's 10, or should I just conclude on our case?
There are no questions for her.
Okay. Then what we are asking is, as my learned friend asked, is to dismiss the confirmation, alternatively to grant the remedy that we submitted, which is a suspension for 24 months to allow the regulation-making process to continue in light of the defects that this court might identify. And we're not asking for costs.
Okay.
Thank you.
Thank you. I take it by that you won't ask for reply time after Mr. Leach has argued?
No. I think I've said as much as we can.
Thank you.
And thank you, Chief Justice and the court, for the indulgence.
Thank you very much. Ms. Engelbrecht?
May it please the court, before I start, I just want to...
Please continue.
May it please you, Deputy Chief Justice, I just want to make sure, I see the clock is on 10 minutes, I take it those are mine, and that Mr. Leach will get his own time. I'll try and see if I can yield some time to him, as it pleases you. I've listened carefully to the debate between the court and my learned friend, Mr. Maneche, and what is striking is that the central theme of this Certificate of Need scheme, which is geographic distribution, hardly had any airtime. It didn't have airtime because Mr. Maneche cannot come to this court and explain that somehow, in consequence of this scheme, there will be a better geographical distribution of services. So, fundamentally, this scheme cannot serve the intended purpose. The problem for the scheme is, as we see, that Mr. Maneche starts from Section 27. The fact that there must be reasonable measures taken to advance access to healthcare. And this measure is not a reasonable one because it cannot get there. It cannot get to the point where people will actually access the services in the rural areas. In this regard, if I may refer the court to Grootboom at both paragraphs 78 and paragraph 95, where it talks about access on a programmatic and coordinated basis subject to available resources, and elsewhere, a coherent and coordinated program designed to meet the state's obligations. This scheme doesn't fall into that category. And the problem is that there are far less restrictive means. Firstly, if I may refer the court to the answer of the respondents at paragraph 217 at page 502. That is where the Director General accepts that there may be means that are less intrusive. The problem is he doesn't tell the court what those are. Apparently, as we understand it now, it was for us to explain what the less intrusive means are. Now, one presents itself from the argument that Mr. Maneche offers to this court. It is the fact that Section 45 of the National Health Act, for example, provides for these public-private partnerships. There is no need to impose a certificate of need requirement in order to enable a condition that public-private partnerships be entered into. Because Section 45, for example, is a less restrictive mechanism which, in conjunction with the provisions of the Public Finance Management Act, will allow the minister, through maybe a carrot, to get private health practitioners to enter into these partnerships. The problem further is that the submissions today say, well, actually, there was no issue taken with this Section 36(3) requirements. That is, in fact, not correct. And we invite the court to look at page 26 and further of the founding affidavit in the record, which explains expressly how and in what way we took issue, that is, my client took issue with the Section 36(3) requirements. As regards the regulations, the question comes repeatedly, well, what would the regulations tell us? Well, it would ostensibly help us to understand what prescribed services are. It would tell us about norms and standards. It would do quite a lot for us. It would help us to interpret, so it is said, Section 36(3). Now, leaving aside the legal problem with that proposition, I invite the court to have regard to Annexure STU4 at page 77 of the record. Those are the draft regulations. So before this challenge, when the Minister of Health conceived of what am I going to do through these regulations, he did not give content to Section 36(3). He did not explain how those various considerations might be taken into account. What he did do was, for example, to prescribe the height of the doors in a health establishment. Now, how that has anything to do with the requirement that we must improve access to quality healthcare, I don't know. So the point is this: despite all the protestations that the regulations would be the panacea, it cannot be so, not if we have regard to what the minister proposes to do when he has this power. I want to make one final submission, and it relates to the question from Justice Collopin to my learned friend, the example of the direction towards either Midrand or Thohoyandou. The problem is this: when we talk about limitation of rights, we understand that the limitation of rights is only possible through a law of general application. So when there is a limitation that exercises in particular circumstances, it is not a law of general application. And what we cannot do is await individual circumstances, say, well, it might operate unconstitutionally, but we won't declare it unconstitutional. Because, as my learned junior put it, say, for example, there is a statute that defines a crime in an unconstitutional way. This court would never say, well, that's all right when that criminal is convicted of that crime, then he can come and complain. He can't complain now. And it's the same here. It's not to say that each and every health practitioner who is affected is to come on their own to this court. I mean, this court already has too much to do. Inundate it with one application after the other about the particular application. If it operates unconstitutionally, it falls to be declared as unconstitutional. I make those submissions only, and I yield the time that I have left to Mr. Leach. Yes, but you now have extra. As it pleases the court.
I think I'm entitled to 8. 8, Chief Deputy. I'll take whatever I can get, Deputy Chief Justice. Beggars can't be choosers at this stage. Let me get straight to the point then. There was a debate with my learned friend, Mr. Mainechi, around the question of Chapter 10 and whether or not norms and standards were required to be addressed through the certificate of need provisions. And there's a simple answer to that. The simple answer is this, and it lies in a question. Will the certificate of need that is issued by the Director General under Section 36 override Chapter 10? Will an officer, a health officer or an inspector exercising his or her functions under Chapter 10 be not able to do that because the certificate of need has made provision for it? And the answer must obviously be no. And once that is so, once it has no role to play in Chapter 10, then it has no role to play, full stop. There's a second proposition, which is this. For 20 years, since May of 2005, we have operated without a certificate of need dictating norms and standards. For 20 years, the regulations and more latterly Chapter 10 have been in effect. Why it suddenly requires that it be implemented as an ancillary measure at all, our learned friend, with respect, couldn't explain. He drew an analogy, or tried to draw an analogy, with the Mental Health Act. There are regulations published under the Mental Health Act which limit a license to a particular premises. That is the affordable medicines case. It is not, as was pointed out to our learned friend, analogous to a situation where you cannot practice in a particular area. It is the licensing of a particular premises, and that is the general regulations published in terms of the Mental Health Care Act 17 of 2002, and it's the Regulation 43, the guidelines for licensing. My learned junior wrote that, and I hope I read her handwriting correctly. The answer to the question that Justice Colopin posed to my learned friend about Thohoyandou versus Midrand, Ms. Engelbrecht has already given some submissions in that regard, but I would just want to add this. The law of general application, like the curate's egg, is either good or it's bad. It can't be good in part and bad in part. And if the court finds that there is a limitation that is imposed by the certificate of need provisions, and that limitation is not justified on the Thohoyandou example, then it doesn't matter with respect whether it's justifiable in relation to the Midrand example, because there has been no attempt made either in the Act or in the arguments that have been put before the court to limit the application of the sections in that way. So they're either good or they're bad, and that's the zero-sum game that the department has been playing with the court. A zero-sum game that invites the court to uphold everything or nothing. And I've made the submission already that that's an unfair position to put the court into. We have also now heard for the first time in the arguments today that there is an alternative remedy that is being proposed. It's not a remedy that appears in the affidavits, it's not a remedy that appeared in the heads of argument, and it certainly wasn't a remedy that appeared before the High Court. And if I can just pause there. It's the end of the heads. Oh, it's apparently at the end of the heads of argument. I apologize. But if I can just pause there and say this, we find it difficult, and I understand that our learned friends in court today were not before the court a quo, but we do find it extremely difficult to criticize the judgment of the court a quo in circumstances where, as has been made clear in the affidavits in the Rule 31 application, in circumstances where it was conceded on behalf of the department before Millar J, it was conceded before him that it was an all or nothing. Section 36 to Section 40 operated as a scheme, and if anything went, then everything went. So it's unfair to criticize the court a quo, and that was the position a quo. But also, we can pass out into micro particles an impugned section. And we can break it down to the point where we can say, well, that word is objectionable or that phrase isn't objectionable. But really what we have here, and that's what it's been referred to in the answering affidavits on behalf of the department, it's been referred to in submissions before the court, and it's generally been accepted that there is a scheme. Keeping Section 40, because in and of itself it's inoffensive, makes no sense when Section 40 has no meaning apart from and unless it's linked to Section 36. So to try and keep Sections 37, 38, 39, and 40 because they may or may not be offensive looked at through a different lens doesn't make sense when they have no purpose or meaning outside of Section 36. So once one goes, everything goes. We've also heard today that a debate about alternative remedies, and it's clear that there are alternative remedies. The court has come up with some. We suggested, or not we, my client Haase suggested that there was one which was shipping people in. And we're not suggesting for any manner of moment that that should be somebody from Zanin who is brought to Johannesburg, because the person from Zanin will go first to Elam Hospital, and if Elam Hospital needs to refer, then they will refer to a hospital in Polokwane. There's no disruption in that sense. But what you cannot do is you cannot have a tertiary hospital established in every village. It doesn't work that way, and it doesn't work anywhere like that because cost effectively it's not a reasonable proposition. But what the department's affidavits said was that in sum, the purpose of the scheme and sections 36 to 40 are to ensure more equitable geographic distribution and not about resources. And the question that we've been debating before the court is whether or not the scheme fulfills that purpose, and it plainly doesn't. But I know it's late, if I may finish on one submission, which is this. At paragraph 105, at page 210 of the papers, it's the affidavit of Haase, the deponent says, having set out all about regulations and how these things intrude. The deponent says, there is no evidence that these factors were considered at all before the certificate of need provisions were enacted, let alone that they were carefully considered. This failure to take heed of an inevitable and deleterious outcome arising from the provisions constitutes a failure to regard relevant considerations. And it then goes on to have a discussion about rationality. And the importance of that is that you would have expected the department to come back and say to the court, but we did think about this. We did look at this. These are the things that we took into account. These are the things that we thought about that have now been raised by a number of the justices, including Justice Colopin, but they haven't. There is nothing to show that the department applied its mind to what has been described as a blunt instrument that doesn't achieve the purpose that the department on its own version says it should, which is geographical relocation. It's said in the affidavits, House affidavits, that this affects choice. Choice of career according to paragraph 80 of Affordable Medicines. Choice impacts limitation, it's not regulation. And that remains our submission, that this is a limitation, not a regulation. I'm indebted to the court for its indulgence.
Thank you, Mr. Leach. Well, there are no questions for you. Thank you very much.
Court pleases them.
Judgment is reserved. Court adjourns.
Thank you.